for the petition has submitted, instruction on instruction, that the petition wants to withdraw the petition, with a liberty, with liberty. Full stop. Mr. Botakur, I. Botakur, standing counsel for his department for the respondent number 227. And Mr. H. Sharma, learned additional senior government advocate for the respondent number 8. And Mr. S. Bora, learned standing counsel for the respondent number 9 and 10 are present, and they have no objection to the prayer for withdrawal. Full stop. In view of the above submission made by Mr. Dekal and counsel for the petition, and the petition is dismissed on withdrawal, with the liberty as paid for.
FIR is at page 12. What has happened? They have stolen of some e-rickshaw battery chargers and DVR, Lordship, at page 12. At page 17, Lordship, this is the forwarding report, my forwarding report, Lordship. What has happened? They came to search one of my family members.
Okay, Friday or Monday, case diary?
Monday, Lordship.
Monday.
Yes, Lordship, dot 41 a notice they were arrested.
BP Bora, learned counsel for the accused petitioner, and MS A. Begum, learned additional public prosecutor for the respondent state of Assam. 439. Release by case Monday.
Monday, Lordship.
Release by case on Monday. Huh? Monday means 13. 13. Right. For production, the concerned case diary. Yes, Mr. Sharma.
Lordship, earlier also they took for adjournment.
Adjourn. Petitioner not present. Yeah, made. Any instruction?
No, most probably this is earlier they took time, most probably.
No, on 17/3/2021, State Council was asked to obtain instruction.
Then Lordship, it's our mistake, Lordship. No letter, nothing.
The learned counsel for the petitioner is found absent today on call. For Mr. Sharma, learned additional executive.
2, 3, and 4.
The learned additional senior government advocate for the respondent number 2, 2, 4.
2, 3, 4.
You are? Okay. Oh, Mr. A. Bodasaji, learned standing counsel, Revenue Department for the respondent number 1, and Mr. H. Sharma, learned additional senior government advocate for the respondent number 2, 3, and 4 are present. Mr. Sharma has submitted that he has not yet received any instruction in deference to the order dated 17/3/2021. Is the case on
Of June, Lordship, as because we.
Oh, no, it is in the motion says 2021.
is true.
How it used to be this way or that way, either non-representation
Lordship.
or like.
Then by 2020.
Place the case on 20.
Yes, Lordship, 20.
20/05/2024 for appearance of the learned counsel for the petitioner and for instruction
Lordship.
to be placed by Mr. Sharma, learned additional senior government.
Item 4.
Maybe pass over time, Lordship. My seniority is leg in court number 1.
Item 4, Lordship, the case mainly fishery department, most whether they have served copy upon them or not. Their names are not reflected in the
Okay.
cause list.
AFDC, basically AFDC.
Yes, Lordship.
Then next week, you have no urgency perhaps. It is in a motion column. Mr.
Age Islam.
H. Islam.
Age, only age.
H. Islam, Granite Council Board petitioner. And Mr. H. Sharma, Granite petitioner, senior government advocate. Petitioners. Order, respondent number 3
Lordship.
are present. Full stop. The subject matter of the repetition is in relation to a fishery settled by the respondent Assam Fisheries Development Corporation Limited. Full stop. The name of the Learned Standing Council, AFDC, is not reflected in the cause list. Full stop. Release the case again on 15/5/2024, reflecting the name of the Learned Standing Council, AFDC, respondent side.
This is a May month,
15/5.
Lordship, Lordship.
My lord. My lord, Mr. DJ Kopil is coming, is on the way, my lord. For time being, my lord.
May please, your Lordship. Lordship, last order, Lordship, we are asked to dispose of that representation and communicate to us. We have just sought for 15 days more time, Lordship, so we can find out a rented accommodation, Lordship.
When did you retire?
Retired on Lordship in the 22, Lordship.
22.
Yes.
Lordship, we have been informed that a speaking order is prepared. It will be passed by tomorrow, Lordship.
22.
$39.22.
Since then, you have been unauthorizedly occupying the government quarter.
Yes, Lordship, yes. They have
You
been
pay a
occupying-
commercial rent then for the period. You are depriving another government employee. Is it not?
Mhm. We are ready to vacate it, Lordship.
Somebody else is staying in rented quarter. And you know you are retiring on such date. You are required to make alternative arrangement.
We are given 6 months time, Lordship, earlier. that-
6 months, okay. Less 6
Because
months.
the pensions
Rest
were
of the
not-
period.
pensions were not cleared in time, and we had some difficulty with some illness was my wife, Lordship.
No,
So
but
now,
you
Lordship-
know your retirement date on the date you joined the service. No leniency.
we are going to vacate it, Lordship. We are going to vacate it, Lordship.
Speak, tell it. Tell it. Otherwise, we will impose
Yes, Lordship.
commercial rent. Tell it.
We'll vacate it.
When?
Just within 15 days, Lordship. Within 15 days.
Within 15 days.
Yes. From today.
From today.
Yes.
15 days. What is that? 15 days. Today is 6th.
Yes, Lordship.
Okay, 20.
20. Lordship.
20. 20 or 22nd. 22nd. It will be more than 16 days.
Before 20, I will ask them to vacate it.
You vacate it, otherwise.
Yes, yes. On the last occasion also, I made a submission, Lordship.
No, otherwise you'll have to pay. And then I'll order deduction from your retirement benefit. Somebody else is staying in a government quarter because of your non-vacation. Unauthorized.
I will vacate it.
Hard, Mr. And this kind of petition is to be thrown on the first day itself. This is not acceptable. Mr. M. Ahmed, learned counsel for the petition, and Mr. I. Portagood, learned standing counsel forest department for all the respondents. Post of Mr. Ahmed, learned counsel for the petition, has submitted that the petitioner will vacate the government quarter within 15 days from today. Post of release the case on 22nd.
Number 10.
Copy served,
Yes, Lordship.
name shown.
Yes.
That was fixed today,
Yes,
Lordship,
what is the case?
regarding the post of a
Petitioner is serving as what?
supervisory assistant and Seraskadar of the under the district session just Karimganj, Lordship.
The petitioners. And you are agreed by what?
Agree by the promotion of the private respondent, Lordship. He was actually an employee of motor accident claims tribunal. It is a different cadre from the post.
Come to page 52.
52. Lordship.
Ah,
Yes.
so that
Yes,
is the
Lordship. This
genesis. That is a starting point.
Yes, Lordship. That is the starting point.
Now, at that point of time, you were in service,
Yes, Lordship.
all of them.
All of them.
Did you object?
That time, we did not know about disparity, everything, but we have filed an application how he has come from the motor accident claims tribunal to
When?
judicial. 2014, that is we have enacted 11 Lordship.
It
Basically,
is not shown to be received, acknowledged. Eleven.
that after coming to know about the disparity, they have filed another application on in the year 2023 Lordship. Pay enacted
Okay.
12, page 61.
Because this was not receipt of the annexer 11. It is not acknowledged.
But I have
No receipt is shown, not even annexer 12. And you are agreed by now what? 10 years after? Now you are agreed what?
because that is a conditional order, Lordship.
Which was the conditional order?
52, page 52, annexure 5, Lordship.
Well, he has been shifted to the service with pre protection. Basically,
With pray, but
I don't know what kind of order.
yeah, this
but,
so
uh,
shall not be entitled
past
to.
service rendered,
Yes, Lordship.
he is not entitled to claim.
Any seniority over the other
Right.
employees of the
Right.
department.
At that point of time, you are serving as what?
LDA, Lordship.
LDA.
Yes.
So he came above you.
Right.
You did not object. He was granted pre
No,
protection
no,
also.
that time Lordship will have objected as per the statement of the petitioners, Lordship. Kindly see.
Annexure 11.
Page 59, Lordship.
Base 59 is a government letter.
Yes, government letter, that is the different, two different department. He is not the cadre of that judicial department.
Now,
kind of
after
transport
that
department.
order, page 52,
Yes, Lordship.
in 2019, he was promoted to the next higher post. Then 2020, he was again promoted,
Yes,
again promoted.
yes, Lordship. Up
Then
to head
again
assistant.
2021, again promoted.
Yes,
Then 2022, again promoted. 4 promotion.
yes, Lordship.
4 promotion were
But-
affected, were given to him.
It is the,
You remain silent.
not,
Mere submission of representation.
but it is, after knowing about that, he is the different.
10 years
cadre,
is perhaps too long a period.
Notice may be issued and take up instruction from the authority concerned, Lordship.
Third, MSMD, Learned Counsel for the petitioners. Mr. H. Sharma, Learned Additional Senior Government Advocate for the respondent number 1. Mr. H. K. Das, Learned Standing Counsel, Guwahati High Court for the respondent number
2 and 3, my lord.
2, 3. 4 also, 5 also.
Yes, 5, my lord. Yes,
5, 2, 3, and 5. MSMD Bora and MSMD Bora Learned Standing Counsel, Transport Department for the respondent number 4. The petitioners, 3 number, are presently serving as solicitor stroke supervisory assistant in the establishment of the respondent number 2. After joining their services, in 1999, comma 1994, and 1987 respectively. Full stop. The respondent number 6 who was earlier serving as junior assistant in the office of the member, Motor Accident Claims Tribunal, Karimganj, was brought into the establishment of the respondent number 2 by an order dated 7/7/2014 within bracket Annex 5 as a upper division assistant against a newly created post by providing pay protection to him and with the rider that the respondent number 5 shall not be entitled to claim any seniority in the cadre of the UDA in the establishment of the respondent number 2. Post stop. The respondent number 2 was, 6 was subsequently promoted to the post of supervisory assistant in 2019, to the post of registered in the office of the Munsif Karimganj in 2020, comma, to the post of registered in the office of the civil judge. Annexer to the post of supervisory assistant, annexer 6 packeter to the post of registered in the office of the Munsif Karimganj, annexer 7 to the post of registered in the office of the civil judge and assistant session judge Karimganj, annexer 8, and to the post of head assistant, annexer 9 in 2022. Head assistant 2022. Registered in the office of the civil judge, assistant session judge Karimganj, annexer 8 to 2021. Go to 2020. Post. It is the contention of the petitioners that the establishment of the district and session judge Karimganj is distinct and separate from the establishment of the motor accident claims tribunal Karimganj, and as such, the respondent number 6 could not have been brought into the establishment of the district and session judge Karimganj as the conditions of as the matters of equipment and conditions of service of the employees in the establishment of the district and session judge Karimganj is governed by the Assam District and Session Judges Establishment within bracket Ministerial Service Rules, 1987. Issue matter of record from Mr. Das, learned standing counsel to GHC, has submitted that the respondent number 6 was brought into the establishment of the respondent number 2 as far back as in the year 2014, and the petitioners did not raise any objection. Petitioners who were in service at that point of time, did not raise any objection to the order dated 7/7/2014 by raising any challenge until by this writ petition. And as such, the issue has suffered from delay and laches. A matter of further consideration. Issue notice returnable in 4 weeks. As so and so appears accepted. No formal notice. Extra copies within 3 working days. The petitioner shall take steps for service of notice upon the respondent number 6 by registered post PD within 3 working days. Any promotion made to the respondent number 6 will be subject to the counter-replies.
Deeply.
Any further promotion?
Yeah.
Items 11 and 12.
May it be please your lordship, on behalf of R Islam, I want to mention item number 12. He has gone to his native place for casting vote, your lordship.
Casting vote.
Friday.
And
Let
let
it
them
be posted on Friday,
taken
madam.
after 1 minute.
Friday?
Friday,
After 1 minute.
I don't so.
Oh, no.
After 1 minute.
You'll wait for the results also.
In that case,
Mr. M.U. Mondal, Learned counsel for the petition 11. Petitioners. NMS
Kurmi, M. Kurmi,
M. Kurmi. Learned counsel appearing on behalf of Mr.
R. Islam.
R. Islam. Learned counsel for the petition 12. NMS S. Paul. Learned counsel representing Mr. S. K. Taludar, and standing counsel cooperation department are present. MS Kurmi. Learned counsel has submitted that Mr. Learned arguing counsel, Mr. R. Islam, is out of station and has sought listing of both the cases. When date, agreed date?
Friday. Right. Monday. Let it be on Monday, madam.
Monday.
13/5.
13/5/2024. So as the plea is not opposed by the land council for the other sides, leaves the cases on 13.
Item 14.
Procedural also. Otherwise, the third page will be added. No, procedural.
Look, my land was acquired for expansion of the national highway, my lord. I had been compensated in the first and the second phases. I have received compensation released in the first and second. The third phase compensation has not been given to me.
You disclose how much you have received.
That I can do. I'll have to
First
file an
you
additional.
disclose.
Yeah, definitely.
Then only they can respond if you're supposed to receive 15 lakhs.
Yes.
And you have received 5 lakhs plus 5 lakh till date in the first two phases, and you are supposed to receive the balance 5 lakhs. Say, for example,
Yes, madam.
they can respond
I can understand.
without disclosing anything.
My lord, I may be allowed to file an additional affidavit, my lord. Lordship may kindly allow.
Otherwise, vague.
Yes, definitely. I can understand that.
Mr. D. Goswami. Yes, Mr. Verma?
Lordship.
Mr. D. Goswami, learned counsel for the petition has paid for 2 weeks' time to file additional pleadings to bring on record as regards bring on record materials as regards receipt of compensation amounts in the first and second PHA towards compensation for acquisition of his plot of land at village Apar Bagmora. Mr. Any more central government council? No. Mr. H. Sharma.
3, 4, and 5.
Okay, Mr. A. Bhattacharya, Land Standing Council, Revenue and Disaster Management Department for the respond number 2. And Mr. H. Sharma, Land Additional Public, Senior Government
Lordship.
for the respondent number
3, 4, and
3,
5.
4, and 5 are present. In view of the prayer made by Mr. Goswami, release the case after this. Simply over.
My please, Your Lordship. Your Lordship, this petition is revolving around the issuing of a next of kin certificate issued in favor of respondent number 6 and 5, Your Lordship. The next of kin certificate is at page
6.
Yes, Your Lordship.
Where is the
The next of kin certificate is at page 23 and 25, Your Lordship.
5,
23 and 24.
6. Wife of Dr. Hikmat Ali Ahmed and son of Dr. Hikmat Ali. Okay.
Yeah, the petitioners are
What? They are also son and daughter.
son and daughter, your lordship. And this next of kin certificate was issued on the basis,
Respondent number 5 is your stepmother.
yes, your lordship.
Okay. Okay, now where is the next of kin certificate?
That is at page 23 and 24, your lordship. In this certificate, the name of the petitioners are not recorded, your lordship, and that is primarily done because of the affidavit submitted by the respondent number 5 along with the application, your lordship.
So it is a service under Right to Public Services Act.
Yes, your lordship.
There is a provision for appeal.
Yes, your lordship, we have filed that, your lordship. That was
Huh?
not decided, your
Let us
lordship.
see Right to Public Services Act.
They have preferred a representation of the appeal. Even number page.
You have to file an appeal by paying proper fees when an appellate remedy is a statutory appellate remedy is available. You have to prefer that.
Your lordship, here one
All right.
difficulty is there, your lordship.
Huh?
The limitation period is 30 days, your lordship. If you are aggrieved, then we have to prefer the appeal within a period of 30 days. But we came to know about that issuing of the next of kin much later stage, your lordship. So the limitation period already over by that time, your lordship. So we preferred one representation, that is 64, 65, page number 64, your lordship, annexation number 9, your lordship. And that is the appellate authority, your lordship, perhaps.
Did you also prefer any application for next of kin?
No, your lordship, as because already one next of kin has been issued, your lordship. So once one next of kin is issued, another cannot be issued, your lordship. So first, this next of kin has to be cancelled, then the fresh next of kin can be issued, your lordship.
Delay condonation. Delay condonation is very nice.
No, when did the next of kin certificate was issued?
It was issued, your lordship, on
89.
9/21, your lordship. And the petitioners came to know about that in the year of 23, your lordship, the later part of 23, your lordship, when they filed one RTI application to know the status of the next of kin, whether it was issued in favor of anyone, your lordship. Only then the petitioners came to know about the issuing of this next of kin certificate, your lordship.
Okay, in the will, your rights have been recognized.
Yes,
You
your
haven't
lordship.
made
Otherwise, in the will, there is a mention of the petitioner number 1.
as of
But the
one of the
affidavit which is
allegations.
sworn along with the application, your lordship, that there is a false statement, your lordship, that is at
What is
page,
a false statement?
your lordship, that is page 41, your lordship. At para number 2 of the 41, that is the affidavit indemnity bond which was submitted along with the application for issuing of
Mr. Sharma.
Appellate provision is there, but there is something wrong.
Appellate provision is there, but that is not directly applicable to them because in the sense that may file an appeal and any person whose application is rejected may file an
Yes.
appeal to the appellate authority within 30 days from the date of rejection of the application. So that is,
Lordship,
I have
that-
asked them whether they had made any application. They say that they did not make any application. So it is.
Now they have.
It is the response number 5 and 6. Had there been application been rejected, they could have preferred an
an
appeal.
appeal.
Yes, Your Lordship.
But the provision is not there in this act for them to prefer an appeal. Then they have made a representation.
Yes,
where
Your
it
Lordship.
that
That is page 64, Your Lordship, annexure number 9.
That is made in the month of February. Now it's May.
right.
All the things has been,
Lordship, let the notice go, let me get the instruction.
Or you can get instruction whether it is
And it
taken
shall not
into
be a bar.
consideration.
Yes,
If taken into consideration, we can dispose it of
Yes,
by
Lordship.
directing the authority to pass a speaking order.
By that way, Lordship, it can
After
be disposed
hearing
of as
both the-
because apparently, Lordship, they have got some right over there.
Right. In a will, the disease has
Yes.
made the petition number 1 as one of the executors of the will,
Will.
along with his second wife.
Lordship.
So they have a right. So what do you say? Whether it is
Let it be disposed of within
No,
a limit, within
find
a.
out whether it has been
Lordship,
disposed of.
Yes.
No, first find out whether it has been disposed of. If it is
Lordship,
disposed of,
Lordship.
by Friday you get the
Lordship.
instruction. Then, if not disposed of, we'll give a direction
Lordship,
to
Lordship.
dispose of after hearing both the sides.
Lordship.
Right. If something is disposed of, then they have to prefer another application.
Lordship.
Petition.
Your Lordship.
Heard Mr.
I,
M. Huh?
I,
I.H. Law School. Learned counsel for the petitioners. P.R. Mohanto. Learned standing counsel, Revenue and Disaster Management Department for the response number 1 and 2.
Myself for 3 and 4.
Mr. H. Sharma, learned additional public, senior government. Because I was sitting in
Lordship, Lordship.
civil bench, so it comes automatically. Additional senior government advocate for the response number 3 and 4.
3 and 4.
Full stop. Para, the two petitioners claim that their they are a son and the daughter of late Dr. Hikmat Ali Ahmed from his deceased first wife.
yes, Your Lordship.
Deceased first wife.
Yes, Your Lordship.
The response number 5 is the second wife, was the second wife of Dr. Hikmat Ali Ahmed, and the response number 6 is a son of the response number 5. The petitioners have approached this court by the instant writ petition with a grievance that the response number 5 and the response number 6 without disclosing that the two petitioners are also next of kins of late Dr. Hikmat Ali Ahmed, got issued a next of kin certificate on
18.
in their favor on 18/9/2021 within the next Roman 1. Full stop. The petitioners claim that such next of kin certificate has been obtained by submitting affidavits with separation of material facts. Full stop. As soon as the petitioners receive the knowledge, receive the information about issuance of the next of kin certificate in favor of the respondent number 5 and the respondent number 6, day in the year 2023,
23, Your Lordship.
23 or 24,
23, Your Lordship.
23. Day, the petitioners submitted a representation. Which one?
That is
Page
page 64, Your Lordship.
60. Representation before the issuing authority of the next of kin certificate. That is the Deputy Commissioner Borpeta on 7/2/2024. Full stop. The petitioners have approached this court by the instant petition with a grievance that despite submission of the representation on 7/2/2024, the bracket respondent number 3, Deputy Commissioner. The respondent number 3 has not yet disposed of the said representation, has not yet heard the petitioners, and has not disposed of the representation. First of Mr. Sharma and additional senior government advocates will obtain instruction as to whether the representation stated to have been submitted by the petition on 7/2/2024 has been disposed of or not.
Lordship.
Release the case on Friday.
On 15, Lordship.
15.
As because tomorrow election there are.
Okay, 15. Maybe election, Deputy Commissioner will be busy.
Lordship.
Highly recommended.
Oh, doctor, around here. Yes, please, Lordship. Yes.
My lord, petitioner before your lordship, with a prayer for demarcation of his allotted land. In the year 2015, the petitioner was allotted 19 bihas of land as per land policy decision 1989 for special cultivation. And accordingly, the amount was fixed and the premium also paid. After paying and after starting cultivation, the respondent number 4 and 5 claimed that that land, one part of that land was allotted them also in the year 2005. This is the case, and on that situation, the petitioner approached before the civil court and civil court junior division. My lord, decreed the plaint as well as counterclaim, wherein the respondent number 4 and 5 also filed counterclaim. The counterclaim also allowed, and plaint of the petitioner also allowed by part. And subsequently, the petitioner approached the civil judge senior division by filing title appeal. The appeal was dismissed on the ground of maintainability and some legal issues. That is, my lord, the operating part of the appellate judgment is page, my lord, 100.
Okay, 101, paragraph 54.
Yes, my lord.
Okay.
And subsequently, the petitioner approached the circle officer for demarcating the land, and that is pending for a long time. Subsequently, the petitioner approached before the deputy commissioner. And district commissioner also directed the circle officer by passing an order dated 29/7/2023. That is, my lord, the page 109. Whereby it was directed that the circle officer, Mahamura Revenue Circle, demarcated the land in question as per the land records. But that was not done. That is why, my lord, the petitioner approached this honorable court for a direction to the respondent number 3 to demarcate the land, my lord.
Yes, Mr. Sharma,
Lordship.
there are two things. I think petitioner side is claiming ownership of 19 bighas.
Lordship. And out
The
of that,
rival side is claiming ownership of 9 bighas.
9 bighas.
On the same parcel of land covered by, I think, same rag number or.
And subsequently, petitioner's land was demarcated, made separate patta under that number.
Demarcated.
No, my lord, it is separate. Dag and patta was given.
You demarcated and
No demarcation. It is
because it
yes.
this page 110 says
That is-
circle officer Mahamara will demarcate the land in question as per land. That's all. Thereafter, claiming ownership title, they have to approach the court.
Appropriate court.
Somebody enforced or not enforced. Now, only issue is
Demarcation.
demarcation.
Lordship.
Make the line. This is the
Lordship,
demarcated land.
Why it is they are keeping it pending, Lordship?
Hmm?
Why they are keeping it pending, Lordship? I don't.
Thereafter, they will fight it out in a civil court again.
Again.
Possession, claiming possession, dispossession.
Only, we
recovery
have
of
been directed
possession.
only the demarcation part only. Lordship.
Will issue notice.
Not necessary, Lordship, direction.
Hmm?
Or if I have to get instructions, whether or
No,
not
there will be private parties, right?
Yes, my lord.
private parties are there, yes.
No, it will not be
But
possible.
even then, Lordship, only that
Let
demarcation.
them come, then only we can say.
Lordship,
If
Lordship.
they agree, they may be present, they demarcate
Lordship.
the land in their presence. And other rights will be decided by the civil court.
Lordship.
That is the only possible solution.
Lordship.
Because otherwise they will say that we have not
They
been
were
heard.
not heard.
There is already an order. So there is already an order when?
It is, my lord, 29/7/2023.
Okay. So it is circle officer then.
It is district
Heard from Mr.
K.U. Ahmed.
K.U. Ahmed, learned counsel for the petitioner.
For idea. That's phone number.
Mr. A. Bhattacharya, learned standing counsel revenue department for the fund number 1. And Mr. H. Sharma, learned additional senior government advocate for the fund number 2 and 3.
Lordship.
The petitioner is aggrieved by inaction on the part of the respondent authorities, more particularly, the respondent number 3. To carry out demarcation of the land in dispute. The respondent number 2 in miss case number 05/2023, put in bracket annex 13. Episode you had, by an order dated 29/7/2023, put in bracket annex 13. Already directed The response number 3. To demarcate the land in question as per land records. With the further observation that for ascertaining ownership and title over the demarcated land, the parties could approach the appropriate court of law. Fair. Mr. Bhattacharya and Mr. Sharma have appeared and accepted notice. Dispense of formal notice and dispense with, Mr. So-and-so, learned counsel for petitioner shall, however, furnish requisite number of extra copies of the petition along with annexer to Mr. Bhattacharya and to Mr. Sharma within 3 working days from today. Issue notice returnable in 4 days. Petitioner shall take steps for service of notice. Upon the response number 5, 4 and 5. 4 and 5. By registered post with AD. It is observed that pendency of the petition shall not be a bar for the respondent authorities, more particularly response number 3, to demarcate the land in question as per land records in terms of the order dated 29/7/2023. Obliged.
Our name may be shown in the, our name may be shown in the.
The name of the standing counsel, the revenue department be reflected in the respondent side in the cause list.
Finding the item number 7.
May it please your lordship. Lordship, beg your pardon for. Lordship, this is a petition for compassionate appointment, lordship. Lordship, the father of the petitioner was an employee under the Chief Judicial Magistrate Dhemaji. He was a grateful employee, lordship.
Father of the petitioner?
Yes, lordship.
Father of the petition. Father of the petitioner. Okay, he expired.
Lordship, may come to page 21 is the death certificate. He expired.
When? 6/7/2016.
Lordship. 9/7/2016, lordship. 9/7/2016.
And paragraph 6, paragraph 2, you stated wrongly.
My lord, that's a mistake, my lord. Sorry. But I have annexed the certificate, lordship. I'm sorry, lordship.
Yes, thereafter.
Thereafter, lordship, the mother of the petitioner applied for the post of compassionate appointment because for compassionate appointment, lordship, on the in place of that post, lordship, of the father. Lordship, her application is at annexure 2, lordship, page number 22. Now, if lordship comes to page number 3, lordship, page number 27, lordship, that is the rejection order of the mother of the petitioner. Application of the mother of the petitioner. 27, lordship, annexure 3. I'm sorry, lordship, this is a forwarding report, lordship.
Yes.
Lordship comes to now page number 29 at clause 17. This is the vacancy, lordship, which was at that time present there, lordship.
21 number.
She had applied for the post of LDA, lordship. And lordship, 3 posts were vacant at that time. However, if lordship comes to the next page now, page number 30.
Now, that is your case.
No, that is the
Your mother's case.
mother's case, Lordship.
Rupamani. No, you are overaged.
Lordship, but if Lordship comes,
Is it not?
I was at that 43 years at that time.
Is it
Lordship.
correct or not?
Yes, it is correct, Lordship. I was at that time 43 years. However, the Lordship it comes to page number 30 now.
1 minute. Does not fulfill. What is this clause 18? What is the scheme? Why
18, Lordship.
this clause 18? Why? What is the scheme? I
Scheme
think
is at Annexure 7,
if
Lordship.
the applicant is the above overage, then whether that will incur disqualification.
Lordship, the scheme is at.
Is there any scheme?
Yes, Lordship. It is at Annexure 7, page 39.
Page 30. Purpose. Importance.
No, that clause 18 is at Lordship, page 43.
Page 40.
Clause 18, Lordship, middle part. The last line, Lordship, the upper limit limit could be relaxed wherever found to be necessary by the Chief Justice. So there is a provision for relaxation, Lordship. However, if we come back to page 30, Lordship, again, that rejection order of the mother,
30.
30, Lordship, page 30. It was rejected because on the finding that there is no vacant post in grade 3 and grade 4. May I read the second paragraph, Lordship? However, it has been further directed that the case of the opposite applicant may be taken up for fresh consideration as and when vacancy arises in the quota of compulsory appointment along with similar applications. My lord, this after coming to know about this situation, my lord, I could have challenged it before because of paucity of fund and whatever the way I was living, I could not come before this honorable court at that time, Lordship. That is one part of my case, Lordship. But then afterward, Lordship, again, if Lordship comes to Annexure 5 at page 31, Lordship. Lordship, I came to another vacancy error. Since I was allowed to apply fresh again, I applied again, Lordship. The mother of the petition I applied again, Lordship. That is on 28/4/2022, Lordship, during COVID situation, Lordship, when it was it was highly, extremely impossible for us to stay alive, Lordship, because of the financial commission. I had here, Lordship, at the end, bottom part, Lordship, at the last second paragraph, I informed the honorable court that even my daughter is also there who is eligible, Lordship. These are the Lordship, next page, these are the Lordships, are the documents of the petitioner, Lordship.
That is an application by the mother. Also.
Yes, Lordship, mother.
Mother is informed that her daughter has completed MA in English from Dibrugarh University in the year 2021.
Yes, Lordship.
She has applied for the post of LD assistant under the subordinate court of Assam under your control. So if I am eligible, you can consider my daughter.
But this representation has not been considered by the authorities, Lordship. After that, Lordship, these are my educational qualifications. Now, Lordship, it comes to page 49, Lordship. This is my representation, Lordship. For my prayer for appointment on compassionate appointment in place of my father, Lordship. Lordship has got it. Ma'am, Lordship, this application was forwarded by the Annexure 9 at page 58 to the respondent number. Lordship.
So your contention is what?
Lordship.
5% of 17.
Lordship.
5% of 17.
Yes, Lordship. 5%.
It comes to what?
It comes to 0.86, Lordship. 0.86, Lordship.
Eight-six.
Yes, Lordship. Which may be considered as one, Lordship, as per Supreme Court's.
Which Supreme Court? Any idea?
Lordship.
Your synopsis said laid down by the apex court, rounding off. It is in case of compassionate appointment.
Not in case of compassionate appointment.
It will be
It is in case of reservation,
compassionate.
Lordship. But
Because panchayat, voting, all these are different issues. Every case is different. Now,
regarding
anything-
reservation, Lordship.
Reservation, anything on reservation, which is a settled. You have said less than one should be counted as one as per the settle law of the Honorable Supreme Court of India.
Lordship.
So show us at least to make a beginning. Don't show anything about panchayat, voting, ballot paper, all this. On the matter of appointment.
I'm so sorry, Lordship. Lordship, can you give me 5 minutes, Lordship? I was in real hurry, Lordship, today.
Okay, day after tomorrow.
Obvious, Lordship. I'm so sorry, Lordship. There is a judgment on reservation, Lordship, Pawan Kumar Tiwari, Lordship.
Show us that in matter of say reservation, something lesser than one should be counted as one.
Above 0.5 can be considered as one, Lordship. I'll show it. Day after tomorrow, Lordship.
And maybe in the state government, now state government has done away with compassionate appointment. Lordship. Is it before his date? Is
Yes,
before or after?
No, before, after his death, Lordship. I think state government came on 2018, Lordship.
When the state government has come up with the
Family
this date is
14/9/2017.
6/9/7/2016. Means by 5 months. Otherwise, entire salary is to be paid,
Exactly.
right? Third, Mr. DJ Kapil, Land Council for the petitioner. And Mr. G. Bush, Land Standing Council, GHC, for all the respondents.
All the way.
Also. And Mr. the prayer of Mr. Kapil, Land Council for the petitioner, leave the case for Sakti Day. Friday, sorry. Right. Tomorrow is holiday. So Friday.
Lordship.
For impeachment of party, item number 17.
May I please, Your Lordship? My lordship, the state respondent have filed affidavit in opposition by stating that they have submitted proposal, but the amount has not been sanctioned. So I imputed the competent authority, my lordship, who were arranged as suspend number 4 and 5, my lordship. In the original petition, it was, they were not. arranged.
Original petition, they were parties or not?
Yes,
parties?
yes, my lordship, they were
Huh?
parties. They were parties, my lordship.
Where is the original petition?
My lordship. The original contempt petition may be seen, my lordship. Contempt petition, page 9 may be seen, my lordship. Contempt petition, page 9. Respond number 4 and respond number. Respond number 2 and respond number 3, my lordship. Respond 2 and respond number 3.
Two and respond number?
The
1 and 2.
1 and 1 and 1 and.
Why you want to make them party?
My lordship, they filed affidavit in opposition.
Affidavit in opposition.
Yes, by stating that the deputy commissioner forwarded the proposal, but the competent.
Which paragraph?
My lordship. Affidavit in opposition. Paragraph 6 may be seen, my lordship.
6.
And then paragraph 7 also they have stated that the payment will be made after sanctioning from the competent authority, my lordship. And they have annexed also the forwarding letter, page 24 of the affidavit in opposition. Page 24 and 26 also another letter, my lordship. The order is of 2022, my lordship. More than 2 years has already elapsed, my lordship. 10/2/2022 was the order, my lordship.
Because the direction was not against the MORTH
The order.
in the writ petition.
Yes.
Because of the statements made by the
Deputy Commissioner.
Deputy Commissioner,
Deputy Commissioner.
right? He sanctioned, he revised.
Mhm.
So I think at this stage, we can implement the respond number 5.
They were also parties to the.
But there was no direction.
Yes.
We cannot. But since they are he is the authority above the CP engineer and executive engineer and deputy commissioner, this commissioner and special secretary, he can be.
But my lord, at the end of the day, the money has to come for the mode. That part, my lord, we can, my lord, what our thing is, my lord, we can write to them, but
No, we have to be conscious of the direction given also.
Yes.
We cannot expand the scope of the repetition
My,
in the contempt jurisdiction.
yes, my lord, that I
We
understand.
have to be conscious of that also.
Yes,
See
my lord.
paragraph
Yes,
9.
Yes, my lord. That is always there, my lord.
They cannot take the plea there since they are not paying, we cannot. Because they say it as the fact of the assessment and assessment. It is for a competent authority of land acquisition. He has to decide and he has to get the fund otherwise. And these are 2011.
My lord, to implement, my lord.
Because we cannot expand the scope of
I
the
understand, it cannot be, my lord. Because direction has already
direction
been-
is against a
Yes.
particular respondent.
Exactly, my lord.
Though they were responding the repetition, but
Well-
paragraph 9C,
My lord.
the direction to the respondent authority in the public works department. So commissioner and secretary will come within. Commissioner and special secretary will of PWD will come within the respondent authorities in the public works department.
Yes.
But not the secretary, MORT. See, paragraph 9.
Yes.
We cannot expand the scope of contempt jurisdiction.
The commissioner, my lordship,
So,
commissioner special secretary, my lord.
he can be made a party,
Yes,
Mr. Lord,
My lord. My lord.
because paragraph 9, respondent authorities dispose of with a direction to respondent authorities in the public works department to examine and to disburse the efforts. So he comes in the public works department. Third, Mr. SB Law Court, learned counsel for the applicants. And Mr. Ardhor, learned counsel for the respondent number
Respondent number 1,
1, chief engineer.
chief engineer. My lord, he has also retired now, it's 1.5 years. But he has filed his affidavit, my lord.
Respondent number 1. Full stop.
Not chief
The
engineer.
applicant as the petitioner, comma, has preferred the connected contempt application. Contempt case number within bracket C 625/2022. Full stop. The contempt petition, the contempt petition, comma, contempt C case number was is preferred, is filed, alleging disobedience, deliberate disobedience of the direction given to the given in an order dated 10/2/2022, whereby a writ petition, comma, WPC number 951/2019 had been disposed of. Full stop. It was inter alia directed to the respondent authorities in the public works department within brackets PWD, running contempt case of 13 orders, to examine and thereafter, comma, disburse amounts of rupees 4,03,879 and rupees 5,84,724 in favor of the petition number 2 and the petition number 3 therein, respectively. Guys. Full stop. In the said contempt case, comma, an affidavit in opposition has been filed on behalf of the respondent number 1 therein, that is the chief engineer, PWD within bracket NH Works, comma, Assam. Full stop. from the statements and affirmations made therein and the documents annexed to statement and affirmations made therein and the documents annexed thereto, comma, it transpires that the chief engineer PWD NH4 wrote to the special commissioner and special secretary to the government of Assam, comma, PW within bracket, building, Roman and NH bracket close department for obtaining funds for the estimated amount from the Ministry of Road Transport and Highways, Government of India, for early disbursement of the compensation amounts in terms of the direction of this court. Para. The applicant in this has filed the instant interlocutory application seeking implement of 5 DD inter alia seeking implement of Raj Chakraborty is presently Raj Chakraborty
is present.
I have to put as a party respondent in contempt case C number 625/2020. As the said authority has not been implicated earlier, in view of the facts emerged from the affidavit in opposition filed by the respondent number 1 in contempt case C number 625/2022, the implement of the aforementioned respondents appears necessary for consideration of the contempt petition. Contempt case C number 12. Accordingly, the instant interlocutory application is allowed. To stop, Mr. Law Scholar, learned counsel for the petitioner shall file an amended cross title, right? In terms of the notification to the House within 3 working days from today. To stop on filing of the amended cross title, comma, the registry shall carry out the necessary correction in contempt case C number so and so, and in the CIS, and they have to release the contempt case. Then only we can issue notice. Nowadays, things have become difficult.
Yes.
Highly obliged.
Items 18 to 20.
My lordship.
Yes.
Lordship, new incumbent, my lord, have to arrest, my lord. New incumbent, my lord. Initially, direction was given to the chief engineer, public health engineering, and now.
Okay. Repetition to it. Repetition.
In
Contempt case. Contempt case.
Contempt case.
Contempt case. It will contempt case control. 780. Okay. What is the direction?
My lord, direction at page annexure 1, page 9, my lord. And the relevant.
Page 9. Okay. Some work orders.
Yes, my lord. In under public health engineering under
Okay.
sanitation, my lord. Now matters looking into by sanitation.
DHE department.
Yes, my lord. Within bracket sanitation, my lord.
1 minute.
At that time, my lord, no Specification is there.
Your name be heard, Mr.
KI Mazumdar.
K.I. Mazumdar, learned counsel for the applicant. The instant interlocutory application under order 1, Rule 10, Code of Civil Procedure, 1908, RW, Section 151 CPC, is preferred by the applicants seeking implement of the following authority. Yes. Who?
At page,
Paragraph 7 or আছে, paragraph 7,
paragraph 7.
quote unquote করা আছে. As a party respondent in the connected contempt petition, contempt case C number 780/2023. Full stop, para. The contempt petition, contempt case C number so and so has been preferred by the applicants alleging non-compliance of the direction made in an order dated 19/6/2023, whereby a petition, WBC number 6161/2022 was disposed of with a direction to the respondent authorities in the public health engineering department, government of Assam, to make an inquiry and release payment, more particularly, the respondent authority in the so and so, more particularly, the chief engineer, public health engineering department, to cause an inquiry and release the remaining amount for execution of contract works. Para. In the writ petition, the chief engineer, public health engineering department was arrayed as the party respondent number 2. Full stop. It is stated that in the intervening period, the functioning of the chief engineer, public health engineering department has been bifurcated into 2 divisions. Here I did 1, the chief engineer within bracket water, public health engineering department, and 2, the chief engineer within bracket sanitation, public health engineering department. Full stop. The works against which the writ petition was preferred have now come under the authority and jurisdiction of the chief engineer, sanitation,
Yes.
public health engineering department. It is in the above background, the implement of the aforementioned authority has been paid. As a party respondent in contempt case C number 780/2023 has been paid. So stop. Having regard to the above fact situation, above obtaining fact situation, the instant interlocutory application for implement of the aforementioned authority is allowed by any last CS, TS can carry out in the notification. Others are same.
My lord, 19, my lord.
1 minute, 19. Sorry, repetition to change over second.
Yes, my lord,
Repetition to connected to content, yes, 781. Okay. Only repetition to change over, number to 3. Party is same. 1 minute. Public Health Engineering Department, respond number 2A still, WPC number 6216/2022, and order dated 19/6/2023.
My lord, item 20 already allowed, my lord. Already notice has been issued and I have taken steps, my lord. Item.
It will come next.
Yes, Obvious.
WP contempt case to লিখে দিব in view of the case is to be listed in terms of the order passed in I number so লিখে দিব।
Obvious.
21 and 22.
May I please, Lordship? This is for implement of applicant as party respondent number 4.
Huh?
Implement.
Implement.
Yes, Lord.
Applicant. How is the petitioner?
Petition 560 of 2024.
Who is the counsel for the petition?
Not appeared. Not appeared.
This is the first time.
Lordship.
Whether he has objection or no objection, that is to be recorded. Whether Mr. Chetri. Then Mr. Borua.
Lordship.
Yes, you are there.
Item number 22 and there, but not in 21.
Not in 21. It is SN Tamuli.
Yes, Tamil is there.
Then we can put it some other date.
Lordship.
Already on 38th, my lord, it was fixed after 4 weeks, my lord, on last 34 months. This item shall fixed after 4 weeks, my lord.
Prior to that,
No, this is immediate,
Lordship. Yes, Lordship.
Only because
is
I just come, my lord.
Okay. Mr. D. Borua, learned counsel for the applicant, is present. So, sir. However, Mr. SN Tamuli, learned counsel for the opposite party, that's the petitioner, is found absent today on public. D. Borua, Mr. S. Mukhtar, learned counsel for the respondent number 4 and 5 and
Item number
22 are presently. On there is another I in 22.
Yes, Lordship. That is for state.
Okay.
Already they are not undertaking any construction work, so it was not considered.
And you have also IA1.
We file it, my lord.
Applicant in IA21 or IA21. 1280. In view. Yes, okay, Mr. Nayak is also there. Mr. Nayak and standing of the DDD DMC are present. In view on sense of Mr. Kamuli and petitioner in 21. Please the case. When?
After 4 weeks already it is after.
No, this is IA.
On,
Just what are they?
on 14th next.
15.
Must be.
Mr. Tamuli is not there.
Lordship.
It is for him whether to object or not to object.
Must be.
May I please, your lordship? This IA has been filed for implement of the parties, my lord. The applicants herein, they are necessary parties to the writ petition that has been filed as respondent number 5, 6, and 7, my lord.
Where is the counsel for the petitioner?
Lordship.
Yes. Any objection?
No, Lordship.
No objection. Okay. Heard. Mr. Hendik,
Lordship.
you appear for whom? Deputy Commissioner. Any revenue? Council?
Team Onto was there, but some other.
Okay.
You will pay here.
S.
Your
Rabha,
name?
my lord. S. Rabha.
Heard Mr. S. Rabha. Learned counsel for the applicants. Mr. A. Bhattacharya, learned standing counsel revenue department for the opposite party number 1. Mr. J. Hendik, learned state counsel for the opposite party number 2, 3, and 4. Oh, sorry. Mr.
PP Pugan.
PP Phukan, huh? Learned counsel for the opposite party number 1 and 2. That's writ petitions. Which party, huh? Officer Likivo, A. Bhattacharya, OP number 3. And J. Hendik,
4, 5.
State Council, OP number 4, 5, and 6. The instant interlocutory application has been preferred by the 3 applicants, seeking their implement as party respondent number
5,
4,
and 7.
5,
6, and 7.
and 6. 5, 6, and 7.
7.
Party respondent number 20, party respondent number 27, party respondent number 22, respectively. In the connected writ petition, WPC number 1475/2024. Full stop. Where it has been averred that the applicants are granddaughters of late Holodhar Bhuya and late Oruna Bhuya to their father Mitradev, late Mitradev Bhuya, who was the eldest son of late Holodhar Bhuya and late Oruna Bhuya. The connected repetition, WPC number 1475/2024 has been preferred by the opposite party number 1 and opposite party number 2 as lead petitioners. And they are the daughters of late Holodhar Bhuya and late Oruna Bhuya. Full stop. A number of mutation orders have been assailed in the writ petition and according to the applicants, they belong the plots of land in respect to which the mutation orders were passed, belong to the entire family. And as such, the presence of the applicants for proper and effective adjudication of the issues involved in the connected petition. Connected petition is necessary. The prayer for implement of the applicants has not been opposed by the learned counsel appearing for the other sides, including the learned counsel for the plea number 1 and 2 test rate petitions. Full stop. Having regard to the projections made in the aforestated manner and considering the fact that the prayer for implement is not opposed, I extend interlocutory application seeking implement of the applicants as party respondent number 5, party respondent number 6, and party respondent number 7, respectively, in the connected writ petition, WPC number 1475, 2024 is allowed. Amended cost title within 3 working days in terms of the notifications, so registry shall carry out and release the connected petition according. Our repetition will give up. The repetition is to be listed in terms of the order dated order passed today in IS Civil number 1292/2020.
As per earlier order, respondents are supposed to file their affidavit in opposition.
Who are the respondents?
Union of India.
State of Assam.
We are sending it for heading.
Okay.
Similarly, Your Lordship, correspondent 1 and 2.
And what about Union of India?
Lordship 1 and 2.
1 and 2.
Similarly, Your Lordship.
And who are they? Coastal projects? Have they appeared? This Union of United India Insurance.
Respondent number 9, 10, and 11 had not appeared.
Notice sent.
Notice already sent and service is complete, but they had not appeared.
Okay. Mr.
R. Duara.
R.
Duara.
Duara. Learned counsel for the petitions. Mr.
S. Sarkar.
S.
Sarkar.
Sarkar.
On
You are
behalf-
Central Government Council.
On behalf of SP Chaudhary Central Government Council. On behalf of SP Chaudhary Central Government Council.
Okay.
For 1 and
Learned counsel representing Mr. S.P. Chaudhary. Learned Central Government Council for the respondent number 1 and 2. And Mr. J. Hendrik, Learned State Council.
3, 6, 5, 6, and 8.
For the respondent number 5, 6, and 8.
3, 5, 6.
3, 5. 3, 5. 6, and 8. Full stop. Mr. Hendrik has submitted that the counter-affidavit on behalf of the above respondents has been sent for vetting. And the same will be filed within 3 weeks' time. Full stop. Mr. Sarkar, Learned Counsel, has also sought 3 weeks' time to file counter-affidavit on behalf of the number 1 and 2. Full stop. The prayers are allowed to release the case after 2 weeks for filing of counter-affidavits.
May I please, Your Lordship? I'm on behalf of Arts and Sonali. Lordship, as per the earlier date, my lord, while notice was issued in 26/9/2022, the matter was.
Yes, Mr. Hendrik, Home and Political DGP. You represent, I think, all 1 to 8, 1 to 8.
1 to 8.
Any central government council? A guy on.
A Gayan received for 9 and 10.
Okay.
Lordship,
Oh, 2 years.
Lordship,
2 years.
is still lying in with the authorities' possession, my lord, not yet delivered. Not
Yes,
yet
2
any
years.
documentation.
A guy on name is reflected or not? A guy on name is reflected.
Name.
Reflected. You filed your affidavit.
Lordship, I need some time, Lordship.
Hired MS P. Boda. Learned counsel for the petitioner and Mr. J. Hendy. Learned junior government advocate Assam for the respond number 1 to 8. MS A. Gayon. Learned Central Government Council for the respond number 9 and 10. He is found absent today on call. The respondents were put to notice on 26/9/2022. Till date, no counter affidavit has been filed by any of the respondents. Mr. Hendick has sought for and is granted 4 weeks time to file counter affidavit on behalf of the respondent.
Lordships, at least date may be fixed because the 2.5 years gone back.
Not 2.5 years, 1.5 year.
21, date of incident, 21.
26 notice was issued on 26/9/2020.
From
I
the
counted.
incident was 2.5.
Four. File counter affidavit 4 weeks time. Similar time is also granted to the respondent entity to file their counter affidavits. It's after 2 months. On a date will expire hours.
Matter pertaining to non-payment of ex gratia relief. Notice was issued and instructions are called for.
Lordship, my lord, we have filed our affidavit on 29/4/2023. However, respond number 3.
What happened thereafter?
My lord,
Paragraph 5.
paragraph 5, Lordship, my lord, that I have annexed the, my lord, that NOK certificate in the writ petition after the receipt of this amount, Lordship. So still, my lord, it is there pending.
No, however, circle officer concerned is directed to collect and submit the same.
Lordship.
While later dated 14/3/2023. It is stated that on receipt of the mandatory documents, sanction of ex gratia will be processed from the office of the deputy commissioner.
Lordship.
So what happened? That was filed in April 2023.
Lordship, my lord, that thereafter, my lord, no further. discussion
Because
has been-
NOK has been submitted on 8/12/2022.
Lordship.
Documents
Thereafter, my lord,
submitted-
no, my lord, no, my lord, we have not received any instruction, my lord, till.
Have you received any instruction order?
No. No.
Minor.
Get the instruction.
May I submit something? Well, on the last occasion, these batch of repetitions came up before Honorable Justice K. R. Surana. Then this grant of ex gratia matter has been deliberated. And during the course of our argument, we apprised the Honorable Court one judgment of the Honorable Supreme Court that is reported in 2016 9 SCC 627. This is National Insurance Company Limited versus Sashi Sharma.
Let us see, 2016. 9 SSC. Page.
627.
Yes.
There in paragraph 26 of the judgment, it's a matter relating to MSCT case. There the Honorable Supreme Court has stated that no double benefit arising out of the same accident. And there the government, the person was a government employee. So the amount which he was supposed to get as compassionate family pension scheme, that has to be deducted from the MSCT award. If that is being the position, if that is to be deducted, then therefore we made our submission before this honorable court that no double benefit. Therefore, they are not entitled because the vehicle, in this case, the vehicle is identifiable. So therefore, they have the liberty
No,
to
whether it
approach.
is part of, what is the ex gratia scheme? What is the ex gratia scheme then? Whether that was a condition, because one interpretation has already been given in a judgment about the ex gratia.
But now this is.
That one observation, that notwithstanding, I think.
Yes, yes. Your lordship, yes.
Not my also.
One is also there here.
Another one is there. On the basis of that precedent.
But then this.
And whether this is subject to, this scheme is subject to all these conditions.
No, because we are deriving that argument from this particular observation of the Supreme Court.
Right.
And that we have not placed before earlier, madam.
Right.
So paragraph 26 of this judgment, madam.
This is only relating to compassionate family.
What is the scheme? Part of the scheme. Okay, this is the scheme. Page.
Yes, he has an
Next. In page number.
This is
24.
revised.
24.
Revised. Because the phrase ex gratia has been explained in one of the earlier decisions of this court, right?
Yes.
What is ex gratia? And this notification, this scheme is not with any rider.
Yes. Right. Lord, to make kindly peruse paragraph 26, man. It also talks about ex gratia. In the middle, it is said the amount receivable by the dependent claimants towards the head of pay and allowances in the form of ex gratia financial assistance, therefore, cannot be paid for the.
Let me read the
second
entire
time.
one.
Yes.
What is rule 5?
Rule 5 of the Haryana transport, my lord. Haryana family pension.
Where it is mentioned, rule 5.
My lord, paragraph 5. Haryana compassionate assistance to the dependents of deceased government employees rules 2006.
Paragraph 5.
Paragraph 5.
Paragraph starts with.
As the High Court. Then thereafter, my lord, there is a subpara. Subpara 2, whether. It starts with whether. আমার petition. Court management or decision pending complaint. আপনার জিনিস ছিল পিটি করতে আছে দিয়েছি
But no exception has been carved out in respect of government employees in the scheme.
Yes. But if we view the same scheme otherwise, man, if he approaches, because the vehicle is identified, then if he approaches MSCT, even if he gets here that 2 lakh rupees, ultimately that 2 lakh rupees would be deducted by MSCT. Meaning thereby it makes no.
That is an interpretation of Rule 5.
Yes.
And that is in respect of a government employee.
Yes. Yes.
Now, and that is after consideration of the case of Helensi Rebello and other. The facts are practiced as Jean Mahajan. Those were on different plane. There, it permitted two compensation also.
But here are some.
That is an interpretation, okay. But where is your pleading?
Well, therefore, my lord, some time may be granted.
Where is your pleading?
Kindly
We are
writing
submission without any pleading.
Yes, yes.
Will not survive.
No, we have been writing on this line, my lord, to our department.
Thereafter, Lordship, another judgment by Honorable Supreme Court full bench judgment, Sebastian Lacra versus National Insurance Company. In that case, the Honorable Supreme Court held that deduction of government servant cannot be made. Recent judgment thereafter, after his judgment, Sebastian Lacra. In my mobile.
Sebastian Lacra has been distinguished. That has distinguished this.
What is the citation?
Sebastian Lacra versus National Insurance Company Limited.
Citation?
I have not a citation. In my mobile phone, it is.
Art, Mr.
Ardeka.
Ardeka. Here you have not taken the stand, you have taken a different stand. We are just because.
No, we are writing to the department. We are writing to the department. Lordship, may kindly grant us some time.
Okay. Ardeka, learned counsel for the petitioners, and Mr. A. Potasaji, learned standing counsel revenue and disaster management department for the respondent number 1. Mr. J. Hendrik, learned junior government firm for the respondent number 3, 4, and 5. Mr. Potasaji, learned standing counsel revenue and disaster management department has sought for and has paid for and is granted. Has paid for and is granted for its time to file counter-affidavit in respect of the scheme, as gracia scheme, entitlement under the as gracia scheme. Post of such post of. You file your affidavit,
my lord.
Yes, or otherwise you will proceed without any.
Yes, yes.
R. Borua, and counsel representing respondent. Post of. It's like it's accordingly after 4 days.
Much okay.
Item 32.
In this case, pleadings are ready, but I was out of station for 2-3 days, came back last night and could not go through the file. So,
pleadings are ready.
We have filed the affidavit, my lord.
Pleadings are ready.
Everybody.
Filed the reply also, my lord.
Okay.
Affidavit file goes.
Respondents.
Private respondents, I think file. Private respondent file, my lord.
I have also filed. I have
And
filed.
reply to their affidavit also filed by the petitioners.
No, you can post it for admission for disposal.
Yes, on a hearing date, my lord.
After 3.
6th of June.
6 June.
Fine, my lord.
Yes, Sharma, learned counsel for the petitioners. J. Hendrik, learned junior government advocate Assam for the respondent number 1. Mr. H.K. Das.
2 and 3.
Learned standing counsel GHE for the respondent number 2 and 3. Mr. D. Bora. Learned counsel for the respondent number 4 to 10. Stop. Learned counsel for the parties have submitted that exchange of pleading is complete. Full stop. Release the case. Comma as sought for final learned counsel for the parties on 6/6/2024 and endeavor will be made
Right.
for
Right.
final consideration of the litigation.
Big.
Lordship, in this case, Lordship, I am appearing for response number 1 and 2, Lordship. I pay for further 3 weeks time to file our affidavit.
Heard Mr. A. Ahmed, learned counsel for the petitioner. And Mr. DJ Das, learned central government counsel.
Lordship, CEC for response number 1 and 2.
Response number 1 and 2.
And
And
response number
Mr.
3.
J. Hendrik learned New Government Advocate Assam for response number 3. Close to Mr. Das learned CGC has paid for and is granted
3 weeks,
3
Lordship.
weeks time to file counter-affidavit on behalf of the respondent number 1 and 2. Please the case up in 3 weeks.
Much appreciated.
35 to 37. Your Lordship, we have filed application. I like to file rejoinder, Your Lordship. 2 weeks time.
We have filed affidavit long back,
Long
but
back,
Lordship, due to the stay order, Lordship, the Amrit Bharat development project is Lordship.
35, 36, 37.
We are suffering a lot, Lordship. Already LOA is issued for development by station, Lordship. It's a central government fund, Lordship, otherwise, Lordship, we.
Contract,
I know where Mr. Gogoi,
Lordship,
you have filed your counter.
Lordship, we have filed a counter, Lordship.
1st of December, I have filed.
We have filed.
None of the counter affidavit is on record.
We have
In
filed.
none of the 3 petitions.
We have
I
filed,
have my
Lordship.
slip also.
Yeah. Office notice in the first one. 30/11/2023. Right. After November, it has been listed
Lordship.
first time. I don't know in
Yes.
between it is listed or not,
No, not listed.
but on 6/11, all of you prayed for counter affidavit.
We have filed on December, Lordship.
Nothing is then firstly, how much time you require?
Only 2 weeks. Your Lordship. 2 weeks.
And what is the subject matter?
Subject matter, Lordship, regarding they have issued a license for Lordship for temporary Lordship run the business, Lordship. That period is already expired, Lordship. And as per the contract agreement, they have to, Lordship, hand over the land to us, Lordship. And
Railway land.
railway. And that particular land, Lordship, as per the Lordship, it is a Amrit Bharat development project, Lordship. There is still the station development project, Lordship. Already LOA is issued, Lordship, due to the stay order, Lordship, the work is, Lordship, not progress, Lordship. We are suffering, Lordship. It's related to the public interest, Lordship.
Okay.
Stations development, Lordship, and flyover, Lordship, car parking and passengers, refreshment room, Lordship, everything is there, Lordship.
You file your affidavit on or before 17. Reply affidavit. We'll post it on cases 22nd of May.
Your Lordship,
2 weeks
2 weeks.
or on or before 20
20.
May, exactly 2 weeks. Heard Mr. R. Mojumdar. You are in all the cases?
Lordship,
In one cases I am there and my junior colleague is there in 2 cases. He is out of station.
We
Your
can
Lordship.
record your name. Heard Mr. R. Mojumdar, learned counsel for the petitions. MS B. Sharma, you are in which case?
I'm 37.
Who are in 35?
I am for 35.
Mr. K. Gogoi, learned Central Government Council. For the respondents in 35,
I'm in 36.
MSL RDB, learned Central Government Council. For all the respondents in 36, and MS E. Sharma, Central Government Council, for all the respondents in 37. Poster. Mr. Gugui, MSDB, and MS Sharma have submitted that counter-affidavits on behalf of the respondents in all the three petitions have been filed in the month of
December.
December 2023. Okay, December, during the period from December that's February, December 2023, that's February 2023. But the counter affidavits are not tagged with the record. So, Mr. Mozumdar, the counsel for the petitioner, has however submitted that he has received the copies of the counter affidavits filed in all the three petitions and has paid for 2 weeks time to file reply affidavits within 2 weeks time to file reply affidavits. 2 weeks time till the wish to trace out the counter affidavits filed by the respondents, stated to have been filed by the respondents, and to take the same with the case records. The reply affidavits by the petitioners shall be filed on or before 25/2020. Release the cases on 22/5/2020. Order.
My lord, we pay for lordship. Yet the lordship endeavor should be made to the
We'll observe, we'll try.
lordship.
Oblige.
Oblige, lordship.
The interim order passed earlier shall continue till, if any.
Lordship, in this case, final order was passed by the authority. Their allegation is that notice was not served on them. I was directed to produce the original records. Lordship may be taken on Friday, Lordship, because there is some miscommunication. They sent some records, some other case. May be taken on Friday.
Friday have some difficulty. Can you Monday, my lord?
Monday কিমান আছে list কৰিলো নবুলি you Wednesday.
My lord.
Mr. R.S. Mishra, Mr. R.S. Mishra, learned class of order petitioner, and Mr. S.C. Kyle, standing counsel GST for the respondents. Mr. Kyle has sought listing of the case on next Wednesday. In order to enable him to produce the concerned records. So stop, release the case accordingly and so the interim order passed earlier shall continue till the next.
Deeply problematic.
Item 40.
May I please? Lordship, kindly peruse the last order, my lord.
Yes.
Lordship, in this case, what happened? Their registration was cancelled for non-filing of return for 6 months. Thereafter, they prepared appeal. appeal was dismissed on the ground that the authority has no power to condone the delay. On last occasion, this honorable court directed to ascertain whether he has filed the return and not. Lordship, this is a self-assessment. Since his registration was cancelled, so the authorities are in difficulty to ascertain whether he has filed up to date. Even Lordship, even then, suppose he has filed, Lordship, whether delay can be condoned or not. That is the main issue, Lordship. This is
No,
the-
I have already reflected the two cases.
Yes, Lordship.
Singh Enterprise
Yes,
and GlaxoSmithKline
that is the difficult.
law is
Lordship.
settled. So
Otherwise-
for this, yeah, unless you resolve, if you are interested in the money and
No, no,
get the issue settled.
When appeal is not filed, we are conceding to restoring the registration,
Huh?
subject to payment of tax and others. But here, Lordship, this is the difficulty.
Yes, it can be, but what about this Singh Enterprise and GlaxoSmithKline?
This is the difficulty before the authority, Lordship.
What about the ratio laid down by? You may say that you discard all those decisions. For this court, it is difficult to discard.
My lord is absolutely.
Ignore.
My lord, I come before your lordship only on equitable ground.
Equitable ground is not available when the law is settled.
My lord, in our Guwahati High Court already, I have.
Or the Guwahati High Court, my question is to the council, whether Guwahati High Court is, the decision will override the decision of the Supreme Court. Simple query.
Yes, ma'am.
Huh? Otherwise, I am bound by this order of this coordinate bench.
Yes.
But if the law has been settled
Yes.
by the Honorable Supreme Court of India,
Yes.
then which order is to follow?
Obviously, Supreme Court.
Then what to do?
I suggest.
Unless Mr.
Lordship, this is the difficulty with the department. I talked to the officer also. That's what the.
This is the difficulty for the court also.
Yes, Lordship. And Lordship, he may, the petitioner may apply for fresh registration, will consider and will grant Lordship fresh registration.
There is no appellate tribunal under section 112.
Yes.
Now it has been constituted.
Huh?
Now it has been constituted.
At the time when we have filed there.
At that time it were relevant. Now Justice Misra has been appointed as a Justice Misra. In the
Where appellate tribunal is?
Delhi.
Delhi. What to do? Consent cannot confer jurisdiction.
That is the.
Consent cannot confer jurisdiction. Singh Enterprise, GlaxoSmithKline, if it is revisited, it is okay. Otherwise, our hands are tied.
Yes.
Let's see, we may apply for fresh, we'll consider and we'll after.
As per my lord discretion, my lord. Whatever may be come out.
Okay, we'll go to the Glaxo once again, then we'll dispose. What are did you Mongolbar mane did you Mongolbar? Tomorrow to Monday আছে না only. আর Thursday because Tuesday?
Lots.
এই দুটা সময় to book this. We ordered it or এই গাতে লিখা আছে put for us citation paper. Is Glaxo has been reviewed or
No.
no, not reviewed.
No.
That is a 3 judge or 2 judge,
Two judges, probably two judges,
not revisited.
not revision.
Then it will be difficult.
And thereafter, many judgments has come with respect to arbitration also, because same provision is there. There is no power to condone delay. That is
So,
also.
my lord, I have earlier occasion when the matter was come before the another court, my lord. I have relied another high court judgment, but they have relied the Supreme Court judgment, and they had categorically stated that when the matter relates to enforcement of the fundamental rights, that act cannot, there is no any bar by the any act, my lord.
But is it regarding appellate provision?
That is, correct, my lord.
No. We cannot, because of Singh, I think Singh is higher bench,
It is.
larger bench. Singh Enterprise has been followed. Singh Enterprise is old one,
2008. With respect to central excise.
2008. These are taxation laws.
Taxation.
Taxation laws are different from other laws.
Yes. But I have already paid all the, my lord, the.
Right, but
return
to
also.
this order is on the basis of consent.
Consent, yes, my lord.
But consent cannot confer jurisdiction.
Exactly, my lord. Yes, my lord.
Mr. S. Sharma,
Yes, my lord.
Learned Counsel for Petitioner Hart, and Mr. S. C. Cat, Learned Extending Counsel CDST. For all the respondents.
No, lordship.
Respondent number 1.
What do you say? It is you who can do it.
I have to take instruction.
Huh? Also had S. Sharma for the petitioner, K. Pukul, and Central Government Council for the respondent 1, F. C. Kyle, and Standing Council CGST for the respondent number 2, 3, and 4 post of as sought for by the Learned Counsel for the party. Leave the case on Tuesday. We get a live video, seeing our edit.
Much.
Item 41.
You file your counter.
Lordship, criminal matter all disposed of, na?
That matter has been dismissed on the ground that we have not filed any appeal against the order dated 22/8/23. On that ground that we have not challenged the order dated 22/8/23.
No, what is your case?
Now here the 28/23 also there is a direction, my lord, one direction is there.
Kindly peruse page 41 also. The petitioners with
Let us go serially, and I'll understand. Directly to the page 41, I'll not understand. So estate officer declared him as an unauthorized occupant under the public premises,
occupant, Lordship.
and there was an appeal
Appeal, Lordship, and
under section 9 perhaps.
Lordship. And that was,
That
Lordship,
appeal was dismissed.
Lordship. Against that, Lordship, the
Writ petition was filed.
Lordship. That was also, Lordship,
Writ petition was filed.
Lordship.
What is the order in the writ petition?
My lord, may kindly
Page?
peruse page 41 to 47. It starts from page 41, Lordship.
41.
My lord, may kindly peruse paragraph 8, 9, and 10, Lordship. It starts from, Lordship, paragraph page 45.
Paragraph 8 says no infirmity.
Lordship. 9 is also there, Lordship.
9 says he was there for 30 years.
Lordship.
So allow them to submit representation
Lordship. And that was considered, Lordship.
without interfering with the order
Lordship.
to consider.
Lordship. That was considered in page 52 to 53, Lordship. Page 53, Lordship, serial number 5, Lordship, 5 and 7, Lordship. Page 53. And my lord, may kindly peruse page 41, Lordship. The judgment just we have the order we have just forwarded, Lordship. Page 41, Dilip Kumar Das, Lordship. There's a link as Dilip Kumar Das and Manjit Das Gupta. Here is Manjit Das Gupta, Lordship.
Yes, my lord.
Similarly situated.
No, situation is that the honorable single judge, that court, my lord, whichever have dismissed this Dilip Kumar Das case, my lord, that we have not filed any appeal against the order passed by this honorable court. That is the dated 22/8/23. That has been taken into that has been taken into consideration.
This is a common judgment, page 41.
Yes,
41 common judgment.
It was affirmed.
Yes.
The order passing appeal was affirmed. Finding no infirmity.
No infirmity.
Right?
Yes.
Only thing that you prayed for allowing you to file a representation.
Yes.
That was allowed.
Yes.
As per the extant rules. As well as the policies of the railways.
Yes, my lord.
Only that extent.
Only that extent.
So far your eviction from the plot of land is concerned, that has been finalized.
Yes, that has been finalized, but here the court
That has attained finally.
Court has, the honorable court has, your lordship was pleased to allow me to submit a representation before the authority concerned, and that may concern as per the existing rules.
Existing rules, paragraph 7.
Yes, existing rules. Now, existing rules, whether they have complied it. The rule says that existing rules means the Supreme Court says, my lord, that if they are to be evicted, some compensation is to be given. That part has not been discussed at all, my lord. So, honorable court, why he has, when
I am not getting the point.
the honorable Supreme Court
has said that after declaration of a person as an unauthorized occupant,
yes, occupant,
still compensation is directed.
Yes, Mr. Compensation is directed.
Unauthorized occupant.
Yes, my lord. Yes,
right from 2012.
Yes, my lord. Reasonable compensation is
2012 because the estate officer's order is of 2012.
Prior to that, my lord, there is a direction of Supreme Court. If it is evicted, my lord, from unauthorized occupant also.
How you are differently situated because your your petition was
Yes,
decided along with relief.
yes, of course, my lord. The difference
Relief
between
does. How you, and the council is incidentally the same council,
same,
Right?
same.
same council.
Same.
So how do you distinguish
Yes, my lord.
yourself from
Yes.
relief does? That is the point.
Yes, that is the point. my
That
lord.
is the only point.
Yes, ma'am, that is the only point. So here, the honorable court has considered only that aspect of the matter that we have not challenged this order.
Which order?
This order 22/8/23,
Who is
which
the
has
order?
affirmed this one, affirmed the judgment and order of the district court.
Then you have chosen paragraph 9 and
Yes,
Okay.
madam. Yes, my lord.
you
There-
have
there-
chosen that please give me liberty.
Yes,
to
liberty.
file a representation,
Yes, my lord.
right? And your silence since August 22nd, August 2023, by not preferring an intra-court appeal, you have accepted the position till date.
No, of course, my lord. Of course, my lord.
You have accepted the position till date.
Yes, madam. But when this court has.
There is a provision for appeal within a specific time period,
Yes. Specific time limit.
which you did not do so.
Yeah, yes, I agree, my lord.
Don't take that plea.
Now, my
It
lord,
is
that-
not open for you.
yes, then I have been allowed to file a representation before
Right.
the court board.
Yes.
That has been rejected. Against that, whether it lies or not, my lord. It lies. Against the rejection order, the court did not consider that part.
Which one?
When I have approached the authority by submitting representation, my lord, representation has been rejected, prayer has been rejected. Whether any repetition lies or not after that, my lord.
No, had you repetition lie or not lie will not go into that. Whether you have brought anything that railway has any extent policy to rehabilitate you.
That is the law, my lord. Supreme Court says that.
Law, you are an unauthorized occupant, mister.
Yes, unauthorized
Huh?
occupant, my lord.
You have been declared as unauthorized occupant since 2012.
Yes, since we have been. Yeah.
How? Have you preferred any appeal?
No, against that order, but.
Dilip Kumar Das.
No, against that order, we have filed an appeal, my lord.
Have you got any stay?
No, sir. Retable we have filed.
You also prefer an appeal in this case also. Hard, mister. B. Sinha. Learned counsel for the application. And Mr. P. Gogoi. Learned Central Government Council for all the respondents. Full stop. The petitioner has preferred the instant petition under Article 226 of the Constitution of India. Okay, we'll resume at 2 then.
Lost it.
And discretionary jurisdiction of this court. We say an order dated. We say inter alia an order dated 2/2/2024. Order bearing number page 52, dated 2/2/2024. Passed by the respondent number 3. Full story. Para. By the state order dated 2/2/2024, comma, the respondent number 3 has rejected a representation submitted by the petitioner Portion two. A judgment. Portion to a common judgment. An order. Dated 22/08/2023. Passed by this court in two repetitions. VIJ 1 WPC 2016/2014 within bracket Dilip Kumar Das versus in the Union of India and two others, and Roman 2 WPC number 2017/2014 within bracket Monojit Das Gupta versus the Union of India and two others. Petitioner states in brief is that he has been running business in the form of a stationery shop on and from a plot of land measuring 5.50 multiplied by 3.05 square meters, being plot number 7, paragraph 2, CAT cat dash Roman 3, plan number T/5/2012, comma, situated at west side of the Guwahati railway station and covered by tag number 3189 at Revenue Village, west side, Guwahati railway station, comma, Moja Jalupari, district Kamrup Metro Assam. In the year 2006, comma, the principal chief engineer, NF Railways, by this communication bearing number paragraph 5, dated 2/11/2006. Made a proposal. Observing that there were some unauthorized occupation on railway lands in Pandu and Maligaon areas of Guwahati, comma, had observed further that either such unauthorized occupation, unauthorized structures should be removed, or in the alternative, the same should be regularized as per the policy of the railways to get revenue. Full stop. It was noted that a report showed some constructions had been made, and if the railway lands were not prepared, the railways could collect license fees from those persons, who were in occupation of the railway lands. Full stop. The said matter did not culminate into any decision. Full stop. Whereas in the year 2012, the petitioner was served with a show cause notice dated 29/5/2012 under Section 4 of the Public Premises within bracket Eviction of Unauthorized Occupants (close) Act 1971 within brackets the 1971 Act or the Act 1971 or short. Full stop. The petition submitted a reply to the said show cause notice on 12/6/2012 and prayed that he should be allowed to continue his business from the subject plot by granting license in his favor. Full stop. The estate officer NFLs, after hearing the parties, rejected the prayer while in order dated 12/6/2012 under Section 5 of the 1971 Act. Full stop. Agreed by the order dated 12/6/2012 passed by the estate officer NF Railway, the petitioner filed an appeal, prefer an appeal under Section 9?
Yes.
9.
9.
9. Of the Act 1971 before the landed district judge, Kamrup Metro, Guwahati. Full stop. The Court of Additional District Judge number 2, Kamrup Metro, Guwahati. Oh, sorry, the appeal of the petition, appeal preferred by the petitioner was registered and numbered as Miss Appeal number 11/2012. Full stop. The Learned Court of Additional District Judge number 2, Kamrup Metro, Guwahati. Heard 4 similar appeals, including Miss Appeal number 11 stroke 2012, comma, and dispose of the 4 appeals by common judgment and order dated 10/3/2014. Full stop. Affirming the orders passed by the estate officer NF Railways for eviction. Full stop. The appellants including a petitioner, comma, were directed to vacate the railway lands under their respective position within a period of 30 days from the date of the judgment in order dated 10/3/2014. Full stop. Para. Aggrieved by the judgment and order dated so and so passed in Miss Appeal number 11 to 2012, comma, the petitioner having preferred a repetition, comma, WBC number 2017 stroke preferred the repetition 2017 stroke 2014 within bracket Monodit Das Gupta versus the Union of India and 2 others. Full stop. It is pertinent to mention that another appeal, another repetition was preferred by another repetition, comma, WPC number 2016 stroke 2014 within bracket Dilip Kumar Das versus the Union of India and 2 others was preferred by the appellate in Miss Appeal number 10 stroke 2012, comma, which appeal was also dismissed by the common judgment and order dated 10/3/2014. Full stop. Para. The 2 repetitions, comma, WBC number 2016 stroke 2014 and WBC number 2017 stroke 2014, comma, prepared by the present petition, comma, came up for consideration on 22/8/2023 and both the petitions were disposed of by a common judgment and order dated 22/8/2023. or dismissed, finding no infirmity in the orders dated 12/6/2012 passed by the estate officer in April which and the common judgment and order dated 10/3/2014 passed by the learned additional district and session judge FTC number 1 Kamrup Metro Guwahati. Well, it is opposite to extract the following excerpts from the common judgment and order dated 22/8/2023, paragraph 8, 9, and 10. First, it was in pursuance. It was pursuant to the observations made in paragraph 9 of the common judgment and order dated 22/8/2023, the petition observation made in paragraph 9 and 10. The petitioner submitted a representation on 6/9/2023 with a prayer to grant him license and lease of the land under his possession. The petitioner's said representation, submitted on 6/9/2023, has been rejected by the impugned order dated 2/2/2024. Para being aggrieved by the rejection of his representation dated 6/9/2023, the petition has instituted the instant petition. Para. While discussing the petitioner's previous petition, WCPC number 2017/2014, a liberty was granted to the petitioner to submit a representation, and a direction was made to the respondent number 3 to consider the representation inter alia as part of extant rules as well as the policies of the railways. Para. The writ petitioner in WBC 2016/2014 had also preferred a writ petition, WBC number 1608/2014 to challenge an order passed, to seal an order dated 19/12/2024 passed by the respondent number 3, whereby the said writ petitioner's representation dated 6/9/2023 was rejected. Post the accordion bench of this court by an order dated 20/03/2024 has dismissed the said petition WPC number 2016/2014 with the following observations. Paragraph 10. Order. Paragraph. In the order dated 2/2/2024, the respondent number 3 has observed that as per the extant rules and the policies of the railways, there is no provision for granting press license or lease of the railway land under the position of the petitioner stroke private party on payment of necessary fees. First, the learned counsel for the petition, present petitioner, has not been able to show anything, has not been able to show any extant rules or has not been able to show anything on the said aspect by referring to any rules or the policies of the railways. As the case of the petition is found exactly similar to the petitioner in WPC number 160X/2024, within bracket Dilip Kumar Das versus the Union of India and others, this petition is also found to be devoid of any merits. So accordingly, the petition is to be dismissed. Accordingly, the petition is dismissed.
Item 42. Materials. Also, Peru's last order passed on.
Yes, look out.
Plug.
Anything, affidavit?
The instructions I have received in the seal cover.
Export of fish.
No export of fish, my lord.
Huh? Something else. Yeah. Fish species.
Fish species.
You are involved in export of fish.
Yes, my lord. Ornamental business I have, my lord. Fish ornamental business.
For what purpose this instruction was
My lord, the
asked to be placed in seal cover?
Earlier, my lord, this court is directed them to produce the records, but they have failed to produce the record. Then court is observed that there is some materials that may be produced before the case is come.
Now, Mr. Das, come to your prayer. Page 13.
Yes.
Commanding them, mandamus, commanding them to withdraw the lookout circular, if any, against the petitioner.
Yes.
Certiorari relating to issuance of lookout circular against the petitioner in passport number so and so. Now, as per the instruction, without going into other details, because there is something which occurred in the airport.
Yes.
But as on date, there is no lookout circular existing against any of the petition.
Yes, my lord.
Those LOCs were deleted.
Yes. But even then, my lord, why the petitioner is treated like a criminal in the airport authority? That is my.
There is a song, once beaten, twice shy.
That is what, my lord.
You have been caught.
No,
You have been caught.
I have been discharged also, my lord.
Right, but there
And
was
all the seats.
There was some suspicious activity and for which you were caught at the
No
airport.
suspicious authority, my lord. I have been caught with some fishes. That fish is not ambit of the my lord.
No, there are other things,
Species.
things which might not be disclosed by your client. Maybe, but in any view of the matter, the lookout circulars have been withdrawn.
Okay.
As on date against the passport. Petition number 1, we pulled us, right?
Yes.
We pulled us. Then petition number 2 and also petition number
3.
Okay. As on date, there is no lookout circular existing. But something was there on an earlier occasion. And
if anything is there, let us know.
that has been now there because of that activity. You have been screened
maybe
vigorously than the normal passengers.
Yes.
No ban in travel was imposed, but
yes.
that if
There is some
the
suspicion.
passport holders, these passport holders come, search should be made vigorously. That is the instruction. Because once you were found with suspicious things
Not
at the airport,
suspicious, I am very
which we are not required to disclose. As on date, it is without any lookout circular.
So, my lord, my humble prayer is that if there is
it
nothing
closed?
against me, so I may not be harassed.
we can
in the
record
airport
that.
authority.
Lordship,
Mr. Bora,
Lordship.
at present, there is no existing lookout circular existing against any of the petitions.
Yes, sir. Lordship.
And I may not be harassed in the airport authority. That on the basis of this record, my lord. If something is there against me, let them know.
Normal search should be made.
Yes,
Everybody,
normal search,
every person is. But
Normal-
because of your some
No, normal search
earlier
is defined
behavior,
in your
no,
law,
no,
but
that is
but
there.
2 hours, same question, same person, same.
No, that
each
is the
and every-
instruction now,
Yes.
Mr. Then we'll ask for their counter-affidavit. Everything will be disclosed.
My lord, if-
Then
Your Lordship.
present position will continue. Lookout circular has been withdrawn now. You are free to travel. There was no travel ban.
There is no travel
But
ban.
you were caught with something. You tried to smuggle something.
No, not smuggling, my lord. This is my lord, already discharged from the court, your lordship.
That is what the allegation is.
But my prayer is that, my lord, I may not be harassed, unauthorizedly harassed. That is my
No,
humble prayer.
your 2 prayers are not existing now. These 2 prayers,
Yes.
they have said no lookout circular existing.
Yes.
That's all.
With your observation, no, my lord,
What observation?
Harassment.
Normal screening will be done.
normal
There is no-
screening is
Normal screening will be done.
No,
Everybody has to
that may
face
be
that.
done, that may be done. That is, I have no objection, my lord. But 2-3 hours interrogation is,
Now there is
Yeah.
nothing. They have said, we'll
Yeah.
record that.
yes,
Because during your subsequent international visits, customs did not find anything incriminating in your positions. Once it was found, so during the subsequent international visits, you were screened thoroughly. And after your subsequent visits, international visits, since they did not find anything, they withdraw the lookout circulars. Now, as on that, there is no lookout circular. So we'll observe only that if you feel aggrieved, again you will come. But so far, your two prayers are concerned. Now there is no cause of action. They have cleared it. Heard Mr. N.C. Das, Learned Counsel for the Petitioners, and Mr. D.C. Bora, Learned Central Government Counsel. For all the respondents?
All the
Post office. The petitioners have instituted the instant reputation under Article 226 of the Constitution of India, agreed by issuance of lookout circulars against the petitioners holding passport numbers. Agar 1/3/2024. 1 to 3, huh? Full stop. The writ petitioners have made the following prayers. Sought the following writ. Page 13. A, B, C, D. Full stop. Para. On the previous date, comma, of listing, comma, 5/4/2024, comma, Mr. Boral and Central Government Council was asked to obtain instruction in a seal envelope, comma, in the event the respondent authorities do not want to disclose the reasons. Para. Today, comma, Mr. Bora, Central Government Council has placed a instruction in a sealed envelope, comma, which contains a communication dated 10/4/2024 of the FRRO, comma, BOI, comma, Kolkata, comma, addressed to him. Full stop. The communication dated 10/4/2024 contained in the sealed envelope are produced, full stop, as per the instruction contained therein, comma, the lookout circulars, comma, earlier issued against the petition, comma, have been withdrawn, and at present, comma, there is no lookout circular existing against any of the petitions. Full stop. In view of the fact that At present, there is no existing lookout circulars against any of the petitioners holding the passport numbers 1 to 3, comma. There is the cause of action to prefer to continue with the writ petition does not exist. Full stop. The petitioners are, however, at liberty to approach this court again in the event of any subsequent cause of action. Full stop. The communication dated, sorry, 10/4/2024 contained in the seal is kept in a seal cover with the case records. Is to be kept in a seal cover with the case records.
Majo.
Please close.
Obliged,
The reflection stands closed. Huh? No.
May
লিখে দিব আর হাওয়া লিভারি
Matt Vijay Lordship, my lord. The matter came up before Lordship on 8/4, my lord. The matter came up before Lordship on 8/4, my lord. And my lord, matter regarding the establishment of brick lane industry. And then all the petitioner, brick lane industry, my lord, all the petitioner, my lord, they have the agricultural land around the brick lane. And I have challenged this one, establishment of brick lane on the ground that, my lord, it is within the, my lord, agricultural land. And second is, my lord, it is in the eco-sensitive zone. So in 2012, my lord, when NOC is given by the restaurant number 3, my lord, I have filed a writ application and that was disposed of 2013. We giving certain direction that pollution control board and my lord, agriculture officer and my lord, forest officer, they make a, my lord, they make an investigate whether it is within the, my lord, by eco-sensitive zone and by establishing these, my lord, be clean, my lord, whether affect the agricultural land. The report has come, my lord. Thereafter, what happened? The NOC has been cancelled. Thereafter, they have filed another application, a writ application, my lord. In this, there is a, my lord, till today, well, the 6th round of litigation. But last litigation, a writ appeal, my lord, certain, my lord, direction has been given. That direction has been given that before deciding the NOC, the DC has to call report from the, my lord, district health officer, pollution control board, and as well as, my lord, district forest official, my lord. But without, my lord, receiving any report, my lord, there is Supreme Court, my lord, decision is there coming, my lord. That, my lord, that Supreme Court decision that if there is no eco-sensitive zone has been decided, then 10-kilometer radius should be declared as an eco-sensitive zone. So on that ground, this brick lane is fall within the, my lord, 10-kilometer zone, my lord. So that, my lord, their NOC has been, my lord, cancelled, my lord. Thereafter, my lord, they filed another writ application, last writ application, and that writ application, my lord, the direction has been given by this honorable court that they to, my lord, before, my lord, deciding the NOC, my lord, by this DC, my lord, that's number 3, he has to take, my lord, the judgment passed by the writ appeal. The writ appeal judgment say there, my lord, report of the, my lord, district health officer, pollution control board, as well as DFO, my lord. But last order, my DC, my lord, has, my NOC has been, my lord, again revoked without, my lord, calling out the report of that three officials, my lord. On the basis of
yes, who are to respond? Forest.
Yes, forest, my lord, district health officer, and my lord,
Yes.
pollution control board, my lord, there are 16, my lord, respond.
Who are there for pollution?
Only, my lord, sir, only, my lord, till 2012, my lord, they have not operated, they are not able to operating the, my lord, brick lane. But after this order, my impugn order, my lord, which was passed in 1922, my lord, they are operating the, my lord, brick lane, my industry. So, my humble prayer before your lordship is, my lord, this man, you know, that operation maybe, my lord, stayed, my lord, because it affect now our agricultural land, my lord.
Mr. Borua,
But what did
order was passed on 8/4/2024.
Yes, 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 yes.
There is nothing on the.
Yes,
interim
yes,
period.
yes, 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 yes.
So how can
Only thing, my lordship,
all have been asked to file their response? Notice has been issued.
in that case, my lord, when a short date may be given.
Right.
But very, my
This should
lordship,
be-
are very poor people, my lord, entire
Right,
their line
understand.
affected.
But there
And-
is a
and-
detailed
and-
order
Yes, yes.
without observing on anything
Yes,
on
yes,
the
yes.
interim prayer. So making a
All
prayer,
earlier, all the repetition, my lord, there's an interim order.
there is a detailed order.
Yes, 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 yes.
And the
yes.
notice was issued.
Only, my lord, this was
There is nothing on the interim prayer.
Yes, 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 man. That's why. Only one is what.
Yes.
I am for the private respondent number 12.
Oh, you were respondent number 10.
12. He is the person.
You maintained a writ petition, if I remember correctly.
Yes, that
What happened to
petition
that?
attend finality in the order is at page 160. Hereafter, this
160.
160, Lordship. 160 it starts, Lordship.
Okay, what was the order?
Lordship, operative part, Lordship would find at page 160, 7. 10, it is observed by this court that as the order is so and so was passed only on consideration of decline or a petitioner is situated eco-sensitive zone, which is on the face is perverse. The court has set aside the same under such circumstances. The deputy commissioner would therefore be required to carry out the exercise in terms of the order.
You are reading paragraph 12.
10.
10.
10.
Those are very good. For the order is corresponding and concluded.
Paragraph 12, my lord. There's a deduction. 12.
12 is the final direction.
Hence disposal. Order deals with disposal. As you know, issued in favor of the petitioner considering the reports of the stakeholders and giving opportunity to the petitioner as well as the private response hearing of taking into account the order deals with division and department of are permitted to bring them to any further development aspect of. I think your argument there was that Pobitora was not included.
Yes, yes.
Though despite observation by the Supreme Court.
Yes.
Pobitora was not included in the list of.
List of
I
villages.
remember correctly.
Yes, yes. Lordship,
Because of forest department was not doing.
yes, the proposal was
Where is
not
the forest?
finalized.
Where is forest? Yes.
Lordship, what has happened? Lordship would see the impugn order at 169.
Okay.
In the impugn order, every report has been considered.
Yes, Mr. Bhattakur, why you are not filing the affidavit?
Our affidavit is also ready.
Lordship, there are some issues regarding the exact map of Pobitora. And because
That has been going on. In Mr. Bora's petition itself, we found
12, my lord.
that you have not done what was directed by the Supreme Court in respect of Pobitora.
Yes, Lordship, only because of the boundary issue, but we can get specific instruction if this particular
What
industry.
time? What time?
2 weeks may be granted. Lord.
You represent whom? And what about any union government? No. Okay, hi, Mr. R. Burwa, Learning Council for the petitioners. Mr. I. Bhattakur, Learning Standing Council, Environment and Forest Department for the respondent number 1.
1, 2, 6, and
2,
7.
6, 7.
Lordship,
Mr. J. Henry, Learned Union Government Advocate Assam for the respondent number 3, 4. 3 and 4. 2. Miss G. Boral and Standing Council Agricultural Department for the respondent number 5. And PCB and CGC. H. Gupta, Learned Central Government Council for the respondent number 11, and Mr. D.P. Bora, Learned Council for the respondent number 12. Good stuff. the learned counsel for all the appearing respondents have prayed for and are granted 2 weeks time to file their respective counter affidavit.
Can you give me a date, my lord?
Raise the case on after 2 weeks for filing of counter affidavits by the respondents.
Only thing, my lord, only one, from 20 to 25th, I will not here. After that, after 20 to 25th, my lord, I will come outside.
He did this.
29/5? Yes, yes. Oblige, your lordship. Item 58. Man. This matter is related to allotment of house under PMSY scheme. They file an affidavit.
May I please your lordship? Lordship, I am appearing on instruction of Miss N. Bora.
Ann Bora.
Yes, lordship. For PNRD.
Is for whom?
Uh,
Ann Bora.
N. Bora, for PNRD, lordship.
ENRT.
Lordship,
They filed their affidavit.
They file affidavit. But your lordship.
Yes.
due to some personal difficulty, she could not appear today. Short date may be fixed on the next week, lordship.
My lord, there is some contradiction, my lord.
Contradiction?
Yes. They filed, earlier they say we are not entitled. Then inquiry has been conducted. They found that, yes, they has been wrongly left out. Now again, they filed an affidavit, my lord, that we are not entitled.
Okay, we'll consider in presence of MS Bora.
Short date,
Council for the petitioners is present. MS
P. Biswas.
B. Bishwas, Learned Counsel representing MS N. Bora, Learned Standing Counsel, Content and Rural Development Department has submitted, has paid for listing of the case. Next to the video. MS Bora.
They are going to release the house.
Some personal difficulty today. Release the case accordingly.
15/5.
Okay.
For orders, item number 44. This is a review petition, my lord. If your lordships will kindly come to the order under review, my lord. At page 71. First subpara. Pursuant to a bidding process initiated by e-procurement notice dated 14/11/22, the petitioner was awarded a contract that is so-and-so, 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 at a contract value of so-and-so, and a letter of acceptance dated 1/4/23 was issued to the petitioner. It is stated that subsequently a contract was also executed.
Now, what is the ground for review?
Yes, ground for review is, my lord, there is no question of availing any alternative remedy because alternative remedy was availed. And secondly, number, he had no instruction to make that submission. He availed that, my lord. In fact, I'll just show, if your lordships will kindly come to clause number 24.1 at page 89.
The question is not that I am
No, my lord.
that when an order has been passed.
Yes.
On the basis of submission made.
Yes.
That he is not
He will,
missing
no, he will, yes, he will avail.
In order to avail appropriate remedy under the law.
That is where he has gone wrong, my lord. That is the error which has been crept in the order. Now, please come to page 89.
Am I recording it wrongly?
No, Lord, I'm not on that, my lord. The concession which was given.
Okay.
He had no instruction to give that concession for the simple reason that this 24.1 itself under that only.
Then another question will come because
Yes.
there are many observations and review application ought to have been filed by the same set of counsel to confront that. Because I don't think after hearing him on 2 or 3 days, if I remember correctly.
Of course, that I'm not.
You are not privy, I am at least privy to that. That this order has been passed because of his submission. I think Mr.
My lord,
Nayak was also
no.
there.
Okay. No, my lord, the lordship knows the Supreme
Now-
Court says that for any other reason.
The question is,
Yes.
firstly, in order to avail appropriate remedy, that could be a suit.
Or that could be a remedy provided under the contract agreement itself.
Arbitration.
No, that is what, my lord. That's
No,
why please come to
firstly-
page 89.
No, firstly, that I'm just asking few basic questions just to understand. Now, in order to avail appropriate remedy under the law, one could be civil suit. That was the understanding.
Could be, huh?
That was the understanding actually. On that basis, this order has been passed because since you were not absent, I could have confronted with the council what you submitted that day. I could have. Now I'm not in a position to confront Mr. Choudhury. Now, a writ petition, if withdrawn without liberty, one proposition is that another writ petition is not permissible to be filed.
Yes.
And this writ petition is withdrawn with a view to avail
Another remedy.
alternative remedy. Now, by filing this writ petition,
Review petition.
review petition, what?
My lord, what we are trying to project is, number one, the question of availing alternative remedy does not arise because alternative remedy was availed. That aspect could not be brought to your lordship's notice, number one. Secondly, my lord, he should have taken some instruction from the client.
See, this is a court is not in a position to decide those.
No, my lord, if an error is apparent on the face of the records.
Now, what is apparent?
Yes. Now, because there is no question of availing any alternative remedy because alternative remedy was availed and they did not act upon.
No, what is this civil suit remedy?
My lord?
Civil suit remedy is
Not civil suit. That's why I'm saying, please permit me to place page 89. There is a clause in the contract agreement. My lord, I could have filed a writ appeal. Now in writ appeal, court will say you yourself have said. So I can't go to writ appellate court. Please come to my lord, page 89, clause 24.1. If any dispute or difference of any kind whatsoever shall arise in connection with or arising out of this contract or execution of work or maintenance of work thereunder, whether before its commencement or during progress of the work or after the termination, abandonment or breach of the contract, it shall be in the first instance be referred for settlement to a competent authority within 45 days of arising of the dispute or difference described along with their powers in the contract data, etc., etc. So this competent authority, chief engineer, we filed that, my lord. Please come to that complaint which we filed. Page number, one second, my lord, representation. Yes, 59. And my lord, the time was 1 year. Please come to page 59. Kindly see the reference is very important, my lord, where some correspondence took place. With reference to the notice dated 21st of August 23 regarding PMGSY projects, so I wish to inform you that after receiving the notice to proceed on 4/5/23, we began mobilization effort. However, monsoon onset and subsequent flooding have submerged the project area. Safety dictates waiting for flood waters to recede before work begins, and the same was intimated to you via my letter at serial number 4 above. In response to the executive's direction via his letter under reference number serial number 1, submitted a revised work program via my letter under reference at serial number 4. Despite, my lord, by this letter under reference 4, I said the completion period was 1 year, and within that 1 year, I'll complete it. So without explaining, despite knowing the site challenges the executives are concerned, deemed our submission unacceptable without explaining any reason. It is pertinent to mention here that no field officials advised me about how to execute the work in present ground condition of site. Regrettably, a termination notice was issued without any prior discussion notice. The contract allows 12 months time for completion of the project, which will be due on May 2024, and I commit to honoring this timeline. Please understand that revised work program importance tailored for safety and success despite challenges. We are dedicated to project success, etc., etc., etc. So this is my appeal, my lord, under 24(1). And there is no arbitration is provided. This is the only remedy which is provided under the contract. So under the circumstances, my lord, to relegate me to that alternative forum was perhaps the learned counsel did not, I mean, they should have taken consent of the client, my lord. That this is the position, what do I do? And my lord, within 45 days, he is supposed to consider it, that competent authority. And without doing that, they have issued a fresh tender. As a tender, until now, they have issued 4 occasions.
No, I am not into that. I am into the reviewing the legality,
No, my lord.
the grounds.
Yes.
Of
The grounds
for reviewing the order. I am not into either.
review ground is, if your lordship go by the Supreme Court judgments, my lord, one of the expression is for any other analogous reasons.
Show me some authority on this, but otherwise I don't think this, I am not finding it proper and conducive for, if this is in such a situation, I have to review. There will be practice.
My lord, I'll be remediless. I cannot go to writ appellate court. Writ appellate court will say, you yourself had said, you will avail alternative
No,
forum.
what wrong the court has committed?
I'm not on court's wrong, my lord. I'm not saying court has committed any wrong.
Whatever was fallen.
Lord, in fact, one of the ground is, if your lordships will see, we are not putting the blame on the court.
If the council,
Yes,
the council has done something without instruction, there should also be something parallel.
that will be too
is
much.
What otherwise.
No, my lord, that will be too much.
I am not asking for that also, but otherwise it is not too convincing.
No, lordship will kindly see, lordship's power under 226 is also, the review power is also exercised under 226.
Right.
Therefore, it's very wide. In a given case, if your lordship finds that here is a case where the procedural safeguards was not given properly, then certainly lordship.
Those are issues which could have been considered in writ petition.
No.
But
What
that
I'm saying is, my lord, when your lordship exercises power of review, even that power flows from 226 itself.
Right.
So therefore, the contour is, though limited, within that constraint, my lord.
Show me something, otherwise I have seen, because there are situations.
Lordship will have it on Wednesday, my lord.
There are situations, Mr. Chaudhary, that if such a situation, I'm just observing.
I agree with, yes.
There are situations there are decisions of the Supreme Court. If such a review petition is filed,
Same set of counsel should do. There is a judgment.
There are many, 2, 3.
In fact, one arising out of the
We know the name. We don't have to say. And that has been repeated. Whatever was observed there was repeated in another.
No, my lord, we also know to take such a ground.
Say anything.
We should have parallelly also. That, my lord, we didn't like it.
No, I am not saying that, but
No, that
my
will never
answer
do
also, because there are some procedures also.
What I'll try to
I'm not
satisfy
saying anything.
what I'll try to satisfy your lordship is with the judgment for any other analogous reason. That I'll show, my lord. That perhaps within that lordships can. Yes, technically what your lordship is saying is absolutely correct. What is the wrong court has done? Court has not committed any wrong.
And suppose
But question is, my lord,
petition withdrawn without liberty cannot be again permitted to be filed. Sarguja. Now, what cannot be done directly cannot be done indirectly.
No, that's true. But what I'm trying to say is, my lord,
factors are striking.
Tilted against.
Yes, well, because one, that same set. Second, something should be.
No, my lord, we wish to file a writ appeal. My lord, otherwise, if that remains, we cannot file a writ appeal.
Okay.
That is
because I
basic.
observe something, then writ petition will be maintainable. Okay. Try to find out to extricate this court out of the situation also.
Yes. What I'll do, my lord, we will have it on Friday. I'll bring those judgments, my
We'll
lord,
try to
where the meaning of other analogous reasons has been widened, my lord, to include situations perhaps like this. And I'll bring those. I thought it will not be necessary. I didn't brought it, my lord.
Because Chaudhary, I remember the proceedings and deliberations made before passing this order.
Okay.
And 2-3 dates, if 2-3 dates, if you see the
I
orders,
think it was 3-4 days.
try to please convince me, because that was the situation. Ultimately, this is the order passed.
But I have shown that, my lord, that clause and the appeal.
You have shown, but at that time it was not there. I asked repeatedly, if I've said to you also, that please bring the contract agreement on record. Opportunities were given. Then ultimately this was the submission made.
Correct.
Otherwise, I am alive to the
No follow.
situation.
In fact,
But
my lord, I
question
also
is the contours of review.
well, I could foresee this, I mean, question flowing from the court. But I thought for the ends of justice, I must do it. Anyway, Friday, I will bring those judgments.
Mr. Chaudhary? K.N. Chaudhary, senior counsel assisted by R.M. Dekar for the petitioner, and Mr. B. Chaudhary. Where is Mr. Nayak? He should be there.
Next day, he can be there.
Now, standing counsel PWD for the respondents, post of as released the case on Friday.
Well, deeply. I think 45. May please.
What is the petition?
My lord, page for non-convenience order determined 9920.
Okay, contempt petition.
My lord, contempt.
Connection connected review petition. No, what is for today?
My lord, in fact, my lord, there was a review petition filed, my lord, against the judgment pending the contempt petition. And my lord, in the review petition, my lord, the court has observed to, my lord, prefer a writ appeal against the order, my lord. So, my lord, the department is contemplating to prefer a writ appeal, my lord. So, wait for some time, my lord.
My lord, earlier they filed a writ appeal, my lord. Then
Yes,
the honorable.
that is there in the order, my lord. It is reflected in the order that we have filed writ appeal earlier also.
No, what was observed in a
My
review?
lord, the paragraph
Which paragraph?
19, my lord. There was some consent order, my lord, passed earlier in the writ petition, not against which this contempt is filed. Lord, we file review and then, my lord.
No, in the order passed in contempt, some observation regarding deposit has been made.
Yes, my lord, that is to the, that has to be read in context to the order passed in the review, my lord. Because, my
Review
lord, the
just
undertaking.
observed, review just observed that order should have been challenged in a writ appeal.
My lord.
That has not just said that you prefer the writ
My
appeal.
lord, will see paragraph.
It's up to you.
Paragraph 20 and 21 also, my lord, of the review. Paragraph 20 and 21. My lord.
This
This
is
is both in the connected petition. My lord, paragraph 21, in view of the stand taken and having regard to the finding recorded herein above, the court is of the considered opinion that a leave could be granted to the parties to address this court on the said aspect in the connected contempt petition.
Thereafter, on 2-4,
Same date, my lord, this order.
This observation was made
Yes.
that
My lord, the railway has.
actually was not
Yes.
initiated against them. They were unable to pay the land acquisition compensation to the petition. However, in view of the stand taken in paragraph 10 of the affidavit in opposition, the responding contempt can deposit the compensation amount in the account of the deputy commission.
Our contention in the review was, my lord, that cannot be given to the owners, my lord, because they are the encroachers on the
Now,
land. my
that
lord.
position is holding the field. Direction to pay
We
compensation.
can give to the state government because, my lord, it is the government land
No, in
which.
contempt case, we cannot go
My lord,
beyond what has been decided.
my
Now,
lord,
that is the position. Your
Right.
argument, any argument will not do.
my lord. No,
And this court has observed in the review petition also.
yes.
In writ petition also, the honorable court directed them to
I am
deposit
praying
with the
for some
deputy
time, my
commissioner,
lord, because
not
we are
directly to the petitioner.
contemplating to file a writ appeal, my lord.
Contemplating,
Say, my lord, we will file in short, my lord, tomorrow itself.
Already one month is already over, ma'am.
Because admittedly, my lord, it's a government line, my lord. On the government line, compensation cannot.
and Mr. J.C. Gaur, learning counsel for the petition, and Mr. H. Gupta, learning counsel for the respondent number 1 and 2. Also,
Respond number 6, Your Honor. In the contempt.
and Bordoli, MS and Bordoli, learning counsel for the respondent number 4, and Mr. Edas, learning counsel for the respondent number 6. The Mr. Gupta, learning counsel for the respondent number 1 and 2, shall place instructions in reference to the observations made in the previous order dated 2/4/2024 by the next date of listing. First of place that is on 2 weeks of
27.
observation is made.
No.
The
Observations.
Unless you get it straight, otherwise
No.
contempt has to proceed.
In the meantime, the respondent is already retired, Your
Huh?
Honor. Already retired.
Mr. Das, learning counsel for the
Respond number 6.
respondent number 6 has submitted that the respondent number 6 has come in the meantime retired from service,
On 31st of March. 2020.
reaching the age of superannuation on
31st of March, 2020.
31st of March 2020.
Please, Your Honor.
You have to be there.
Yes, sir.
Everything occurred at your time.
Yes, Your Honor.
Item 46.
Date is
Lordship, in this case, Lordship, I am appearing for the respondent number 3, Lordship, Chairman of State Bank of India, my lord. I have filed a miscase, my lord, IA number 162423, my lord, for deletion of the name of the chairman, my lord. What the facts of the case is that, my lord, petitioners some dispute of the credit card facility, that is a respondent number 4. Due to the dispute, my lord, credit card, my lord, then his civil is down. That is a respondent number 5, my lord. In this petition, not a single line or no relief is sought from my lord, from the chairman of the State Bank of India, and my lord, only is that, my lord, respondent number 3 and respondent number 4 and respondent number 5, my lord. Is a 3 companies, my lord, under Company Registration Acts, my lord. So, my lord, is a different identity, my lord. We have nothing to do, my lord, in this particular case. No relief is sought from us, my lord. Unnecessary, my lord, made a party, my lord. That
My
is
lord,
this.
I am for the petitioner. I have filed an amendment petition. It is registered as 2597.
for what?
For my lord, praying for compensation. As it was not included in the original writ petition, we have prayed for compensation now. And also some, my lord, amendment in the cost title prayer.
We'll do it first. One thing you satisfy me. You have got the card from whom?
Respondent number 4, my lord.
My lord, I have got the card from, my lord, it is unsolicited card. Unsolicited card. No request was made.
Right. But you have obtained it.
Yes, my lord.
They have offered you.
My lord,
and
actually,
you have accepted it.
my lord, respondent,
Now, my question is,
yes,
what kind of entity it is?
yes, my lord. On one day, my lord was pleased to tell that
Yes, I remember.
whether respondent number 4 is a private company or public. My lord, I would like to submit today that respondent number 4 is a public company. Originally, it was incorporated as a private company, but later on the instruction of the central government of India, it was converted to public company. I would like to submit the certificate of incorporation to the matter. There are 4 documents. These may kindly be regarded as a part of the record, my lord. Document number 3, my lord.
Will not keep it, Mr.
First toward
Document number where? Where document number?
on the top, document 1. First 2 judgments were provided.
Not judgment, I will not look into judgment.
My lord. Document number 3.
Company is control.
Yes. I hereby certified that SBI Cards and Payment Services Private Limited.
Seen, already seen.
Yes, my lord. This has already been converted in 2019 to public company.
Now, document number 4.
Respondent number 4, this is.
No, document number 4. Where it
Yes,
is mentioned?
document number 4, my
It
lord.
is mentioned here.
Here, page number 92. In the documents, page number 92 of the document, not my document. Last page, my lord. Last page. SBI Cards and Payment Services Limited is a subsidiary of State Bank of India, where in State Bank of India holds 69.51% stake in 2019-2020. It is not a private company, my lord. Moreover, my lord.
I'll ask the question later.
Yes, my lord.
I'll ask the question later. First, let me be clear myself, right?
Yes, my lord.
Now, private company is defined.
Yes, my lord.
Public company is defined
Yes, my lord.
in the Companies Act,
Yes, my lord.
right?
Yes, my lord.
And subsidiary company is also defined,
Yes, my lord.
right? Now, my question is,
Yes, my lord.
right? And the earlier Companies Act 1956,
Yes, my lord.
if company is considered to be a private company,
Yes.
when the number of shareholders are between 2 to 10.
Yes.
Now here, a company is considered to be private company as per the Companies Act 2013.
Yes.
If it has a
200 perhaps.
minimum paid up share capital, right? And 1 to certain
200.
conditions are there.
200.
And a public company, which is not a public company, means a
Yes.
company
Not a
which
private company.
is not a private company and has a minimum
Paid up share capital.
as may be prescribed.
Prescribed.
Right.
Yes.
It is only by minimum paid up share capital,
Yes.
a company becomes a private company or it becomes a public company.
There is also one
And
difference, my lord.
it does not mean that it is an entity amenable under Article 12 of the Constitution of India. Right?
Yes.
Now, next question. State Bank of India is a entity because it is a statutory body
Yes.
amenable under Article 12 of the Constitution of India.
Yes.
So it's an its acts, a petition is maintainable
Yes.
if its actions violates
Yes.
any of the articles in Part 3 of the Constitution. But whether a subsidiary company of the State Bank of India is an entity amenable under Article 12 of the Constitution.
Yes, my lord. That is why, my lord, document 1 and document 2 is provided. My lord, document 1 is a judgment, Supreme Court of India, citation 2002, All India Report, Supreme Court 1598, Director of Settlement, AP and others, Mr. Apparao and another. In page 2 of 16.
Page
2 of 16. 2 of 16, second page, my lord, of the judgments. It is therefore, it is a ratio laid down. It is therefore essentially a power upon High Court for issuance of high prerogative writ for enforcement of fundamental right as well as non-fundamental or ordinary legal rights, which may come within
Let everybody know, come to the specific paragraph.
Yes, my lord. One of the conditions for exercising power under Article 226 for issuance of mandamus is that the court must come to the conclusion that aggrieved person has a legal right which entitles him to
Come to the main observation.
Main observation
Don't
is
depend
that
on the head note prepared by somebody.
Yes, my lord.
Come to the observation.
Main observation is that
Page.
read petition
Page.
page 2 of
Not
16.
that is head note, Mr. Counsel.
Yes, yes.
That is prepared by some lawyer
Yes, my lord.
or editor
Yes.
or assistant editor.
Yes.
Come to the main paragraph of the judgment. In sections are
Yes,
what
my
by-
lord. Page 16 of 16. A mandamus is available against any public authority, including administrative and local bodies, and it would like to any person who is under a duty imposed by.
What is to any person?
Yes, my lord. Under Article 226 also it is provided. That is the basic difference between Article 32 and Article 226 of the Constitution of India. That remedy under Article 232 lies only if it is a state.
Or any other person to any other, for any other purpose.
Yes, my lord.
I think that is there in the Constitution 226.
Yes, yes, my lord.
I think I have that much of knowledge that
Yes.
for any other purpose to any other person.
Yes, my lord.
Now, what are the parameters?
Yes, my lord. That is I am going to state, my lord, parameters.
This is a public function they have recharged.
Yes, my lord. Public.
SBI card company by entering into a credit card or debit card.
Yes, my lord. Public function is.
An individual, they are, whether statute has given them this public function, whether any statute have given them.
My lord, they can carry on.
Mr. Counsel, whether any statute
Yes.
has given or entrusted the duty to SBI Capital Market to discharge a public function of entering into contracts for credit card with any citizens of the country.
Yes, my lord, company law.
Take this.
And my lord,
We'll decide. Right.
and my lord, Reserve Bank of India Act. Reserve Bank of India Act granted them license. My lord,
It is the relationship the company vis-a-vis the petition.
they have a public duty, my lord.
Yeah, what public duty?
Yes, my
Tell
lord.
me.
Public duty, Reserve Bank of India Act.
For what it has come today?
My lord, what happened, my lord, in this time only
Why it has come today?
is for,
For
my lord,
orders.
for this, regarding that IA, my lord, for IA, for where I have made a prayer to delete the name of the chairman of the State Bank of India, my lord.
Pankaj Muzumdar.
Use my lord amendment.
My lord, 378 page, Reserve Bank of India Act, Section 45 IA. Reserve Bank of India Act, Section 45 IA. Section 45 IA, Reserve Bank of India Act.
How you have got the credit card? Where
My lord, that is the fact. They
that
have,
is the fact.
they have,
Where you have
yes,
paid-
my lord, they have themselves.
Which paragraph? Which paragraph?
Oh, my lord, original petition, I would like to go. They have contacted me and offered me a credit card of say 7 to 10 lakh. But I asked them to send the terms and conditions only. But they have sent a card, my lord. When I received the envelope, I opened.
That story is all right.
Yes,
You
my lord.
received an envelope with a credit card.
Page 10 and
With
page
a
10 and
credit
11,
card,
4 and 5.
with a credit card inside it.
Yes,
And with the
20,000.
terms and conditions, right?
Yes, my lord.
To that extent, everybody, most of us have received
Yes.
such kind of envelope with a credit card inside it with the instruction how to activate it.
Yes.
Now, how you have activated it?
No, I have not activated because it is a credit card of rupees 20,000.
Where is SBI card company? Any respondent appeared?
No, my lord. Respondent on 2, 4, and 6 has not appeared yet. Notice was duly served. There is a office note from Honorable Registrar in this regard, my lord. They have given wrong information to civil, my lord, and my civil score decreased, and I have serious damage to my business. I also invest in MSME enterprise. My loans were stopped by bank. My contractual rate, PWD contract, construction of 5 crores value to be completed within 9 months, my lord. Seriously hampered due to this, my lord. I have to take in private finance at high rate of interest. Ultimately, public works was hampered, my lord, chemist.
No, sir, I'm not still convinced how this card got activated.
Card was not activated, my lord.
Huh?
Card was not activated. I asked them to take back the card, but they did not take back the card, neither cancel the card nor take back the card.
No, how?
They
how
have,
this
they have
3,100
they have told me that I have a area of,
reflected.
yes, my lord. They have told upon me that I have
At
a
least,
have a area of 3,177.
right.
Because
Mr. Nath,
because civil score is very
Mr.
much.
Nath, because
My lord, this is issuance fees.
Please. I want to know because I had received at least 3-4 of such credit cards in envelopes, which I did not activate.
Yes, my lord.
I kept it by the side as soon as I received it. I never received such kind of information that your card got activated. This way, that's way you pay money. I received 2-3 times minimum. If I don't, right now I cannot recollect, but at least this kind of credit cards inside an envelope, I had received at least 2-3 times.
Yes, my lord.
Which I after receipt of which I did not react. I kept it like this, right? And thereafter, I have not received any letter from SBI. So that is why I want to know how this petitioner, if he has
Yes,
not
my lord, that is the
activated the card,
yes,
how can he receive this kind of information?
my lord, that is the fact. My lord, in case of my lord,
And disputed questions,
my lord,
which cannot be gone into in a writ petition.
my lord,
Petitioner is not giving the actual facts because I have the experience of receiving such cards.
no, my lord, in case of my lord, this type of
And
cases
other
does
facts,
does
other
not affect,
issues, legal issues, leave apart.
this does not issues my lord. This case cannot harm
And
my lord.
yes, SBI
my
is
lord
not an entity covered under Article 12. That is the legal issue.
My lord, I can prove that
Petitioner
it is
not
also,
disclosing the proper facts.
it is included within Article 12, my lord. I can prove it, my lord.
Prove it.
Yes, my lord.
100 judgments, I am not still convinced.
My lord,
The prayer of Mr.
for
LP
providing
Nathaniel
one
Counsel
date may kindly be given.
is after 2.
I am going to
That
prove it.
judgment does not help you.
Now, this judgment does.
Director of Settlement.
Yes, this does not help my. That is why I pray before the honorable court to give another date. My lord, by
After
applying
2 weeks.
golden rule,
But
my lord.
After 2 weeks.
I have a prayer, my lord. In this case, what happened, my lord?
We'll decide your
Yes,
application.
my lord, what happened, my lord? For I have a prayer, my lord. I have a filed a miscase, my lord, in 2023, my lord. Where
Is it listed?
Yes, my lord. That's a I number 1624. That would be either reject or allowed, my lord. Kindly heard this matter. Last 1 year, my
No,
lord.
my lord. That is
Let me finish. Let me finish, Mr. Counsel. What happened, my lord? In this particular case, chairman has made a party. State Bank of India, my lord. What chairman has to do, my lord? Not a single line against the chairman's, my lord. No relief is sought against me, either in the main petition, in the amendment petition, my lord. And there is only they made a party, as because, my lord, they are the subsidiary company.
No,
My lord.
Enough.
in the amended petition, relief is sought.
Sir will decide this. Your application will be taken up.
My lord, kindly.
On the next date of listing, consideration will be made to the
I number
interlocutory application
1624.
1624 2023.
29 5. Obligation. I am for the respondent.
Mr.
K. Das, your lordship.
Kedas.
Yes.
Wikidoc, present. Mr. Alpina, petitioner. A. Das, Learned Counsel for the respondent number
3, your lordship.
3. R. Sensua. October, Learned Counsel for the respondent number 5. A. Gayon. Central Government Council for the respondent number.
Item number 47.
May I please, your lordship? This case filed for restoration of WPC number 546 probably 2021, lordship, by recalling the order date 22/4/2024. So it's my fault, lordship, on this earlier occasion. Your lordship has considering that service is completed upon the respondents and directed to be listed for the admission hearing.
This is what? This is for what?
Restoration.
What is the order? Where is the order?
Page 18, lordship. On this occasion, we have not appeared, lordship. Thereafter, before that, on 11/4/2024, matter was listed, lordship, and lordship has considering that service upon the respondents complete.
22/4. Why you have annexed the cause list?
Lordship, cause list. If lordship peruse the page 13, lordship 20. His name was reflected, S.N. Sharma. He was already expired, lordship. S.K. Kejriwal. His leave of absence was reflected in that cause list, lordship, and R. Ali was out of station, lordship. Only R. Ali, lordship. He was out of station, lordship, on this death. But I was in the court, lordship, in court number 26. One part has matter is going on, lordship. I have stated in paragraph 8, lordship.
Yes, Mr. Talukdar, what to do? Suppose a coordinate bench is available, that court has dismissed it for non-prosecution.
Lordship, not available. I think
that is available.
No, lordship. That is available. No, lordship, not available, lordship. Now I think
Not available.
Not. I think now it's Nagaland or Arunachal. In a retribution, lordship, we have raised a serious issue, lordship. In spite of the civil court order,
That we are not going into that. Anybody appeared in the petition for respondent
No,
number 2 and 3?
No one has appeared.
Huh?
No one has appeared.
And who was there otherwise?
Lordship, respondent to service upon his was completed, Lordship, as per the Loazima Court order dated 10/2/2023, and we have the member of the Assam Board of Revenue is also implicated as a party respondent, Lordship.
Your call number was there.
Lordship.
You were counsel in the earlier petition.
Lordship, I appeared, Lordship.
No, engaged counsel or not?
Yes, Lordship.
You had file power or not?
Lordship, I have
No call number perhaps, because name is not reflected. But Mr. K. Kolita, learned counsel for the applicant. First off, the instant interlocutory application is prepared seeking restoration of a writ petition, WPC number 5464/2020, which was dismissed for non-prosecution on 22/04/2022. First off, the applicant as the writ petitioner, had preferred the writ petition, WPC number so and so, against an order dated Oh, your appeal was dismissed for.
no, Lordship.
Huh? Oh, kind of assigned her name revision correction. Mr. Kolka, there is a notification of 24 July 2023. If the honorable judge is not available, then he's sitting in outlying permanent benches. Then it is to be by video conferencing. Right. So I don't think it is proper for me to pass an order. If he is sitting, any tied up matter you see, Mr. Taluga, please sit at notification. I think if I read it properly, then
Probably earlier the practice was in the administrative side, it would.
right. Now, since the concept of video conferencing has come in, it will come within the full
Video
correction application. And all this, including review petition. If the judge is not sitting in principal seat, sitting in any of the outlying benches, it is to be
By video conference.
by video conference. I was about to pass the order. Sorry. As the instant interlocutory application is preferred against against an order dated 22/4/2024. Whereby the repetition command WBC number so and so. Probably one WBC too. WBC number question 5464/2021 was dismissed for non-prosecution. The registry to list the application after ascertaining the aspect by annexer two. Registry to list the application before the appropriate bench in terms of the notification number 87 dated for 24/7/2023. Okay. Mr. Kwelde, you make an application, take this copy of the notification. Make an application before the registry, it will be proper. Then there will be clear.
Wait,
Yes,
Lord.
MS Board.
As per the office note, the service of applicant sole respondent evidence.
It's not
Lordship.
dated. It has only gone on 19/4.
Lordship.
After 2 weeks.
Lordship.
Third MSP border land council for the petitioner. So in view of the office note dated 5/1/5/2024, await for the service report in respect of the
Sole respondent.
sole respondent. List the case after 2 weeks.
Obvious.
Item 49. Maybe also. Lordship. Kindly see the order dated 21/1/2024, Lordship.
21/1/2023.
21/1.
Yes.
21/1?
2024.
21/1, there is no order.
Lordship, 24, 24/1, 24.
Apportionment.
Yeah, yes, Lordship. So, Lordship, it is a case covered, Lordship, under section 3(4) of the National Highways Act, Lordship. It should be decided by the civil court, Lordship.
So why you are fighting here?
No, Lordship, I made representation, Lordship, but it was not sent to the civil court, Lordship.
Okay. And why it has come for orders?
Lordship, because the
Service.
Yes, Lordship, in last order, Lordship, notice was issued, Lordship. Otherwise, they filed affidavit, Lordship. Kindly see their affidavit. One thing I would like to know, Lordship.
1 minute. Who are your partner is, your competitor is what? Opponent, respondent number 5.
Yes.
Whether he has been served.
Yes, Lordship.
Not served.
No, Lordship,
You wait, then we will decide.
Lordship, otherwise, Lordship, it is clear from there is a dispute, Lordship, regarding the apportionment, Lordship.
It has not come for that. Later, DDO will decide.
Lordship, because
It has gone only on 25/4/2024.
yes, Lordship. Otherwise, Lordship, kindly see the affidavit just for a moment. I am with the court, Lordship. I am not disputing anything.
Right. I also feel that it should be relegated to the civil court. But let respondent number 5 appear. Will decide this. We will give a fixed date. Heard Mr.
Yes,
A.J. Ahmed, Land Council for the petitioner. Who is the other respondents?
National Highways System.
Any say? Yes, K. Fukan? And K. Fukon, Lawrence Central Government Council for the respondent number 1. C. Bora is not available. Mr. B. J. Talukdar, learned senior counsel for the assisted by Mr. A. Chetri, learned counsel for the respondent number 5, 6, 5 and 6. Deputy Commissioner and Additional Deputy Commissioner.
Yes, 4 and 5.
Huh?
In my copy, it's 4.
5 and 6 here.
Yeah, Lordship, there is a amendment cost title, I think.
Okay, amended cost title.
Yes. Because already what IFR spec of Lordship, the NFDCL.
4 and 5. 4 and 5. Full stop.
There is Lordship.
In view of the office note. NHA council is shown or not? Okay, shown. None has appeared for the respondent NHAI authorities. Full stop. In view of the office note dated. Hardly 7-8 days. 25/4/2024. Await for the service report in respect of the respondent number. Private respondent.
Yes.
Release the case after 2 weeks. You remind me that.
But kindly fix it. Yes, the Lordship. Yes,
Okay.
I have this.
In fact, my lord, my account has been defreezed now after filing this case. Yes.
Heard Mr. S.C. Biswas, learned counsel for the petitioner. Mr. B. J. Talukdar, senior advocate assisted by Mr. A. Chetri for the respondent number 124. Full stop. The petitioner has prepared the instant petition with a grievance that her savings, her or his, her savings bank account number payout of maintained at Union Bank of India, Nagaon branch,
In the
district
corporate-
Borpeta.
Yes.
Savings bank account with IFSC IFSC number. Was decreased, was freezed by the respondent authorities. Full stop. The respondent number 5, the respondent number 2 has filed an affidavit in opposition, wherein it is stated that after causing necessary inquiry, after causing necessary inquiry, a written request has already been made to the bank authority, that is respondent number 5, that is the branch manager, Union Bank of India, Nagaon branch, district Borpeta, on 19/2/2024 by the officer in charge, Borpeta Police Station, within bracket, the respondent number 4, to defreeze the petitioner's savings bank account.
Yes.
Mr. Biswas, the counsel for the petitioner, submitted that the petitioner's savings bank account has since been defreezed. And as such, there is no live cause of action to proceed with the writ petition. In view of the statement made by the respondent number 2 in his affidavit in opposition that the petitioner's savings bank account has already been defreezed, and the submission of Mr. Vishwas that the petitioner is currently operating the savings bank account, the instant writ petition is closed as there is no surviving cause of action. DGP statement is recorded. Yes, Mr. Sinha.
Yes, my lord, there is a requirement of amendment of the petition. I may be allowed. I mean, there's some mistakes are there, wrong typing of that number, pata number. I have to amend my lord. And I may be taken after amendment, not now.
You have to file a petition seeking amendment.
Amendment, man. Oh,
and
yes,
also the amended writ petition.
Yes, mother, sir.
Then I will allow.
Yes, ma'am.
I don't think this is correct.
Yes, sir. I may be
This
allowed
DAG
to.
number, pattern number, it has changed the nature and character of the writ petition.
Yes, mother, sir. I may
You
be allowed.
don't press this. You don't have to press. We cannot allow this.
No,
I have to dismiss this.
Writ
Because
petition,
your whole DAG number, no,
yes.
on the writ petition.
Yes, mother.
Otherwise, I have to, because the
Or I
whose mistake is this? Court mistake or your mistake?
on our mistake. Madam.
Then you have to.
So we have to amend, my lord.
A petition seeking amendment.
Yes, my lord. Yes.
As well as the amended petition.
I withdraw the IM, my lord. I may be allowed to withdraw.
Mr. B. Sinha, Land Council for the applicant, writ petition has submitted that the petitioner, applicant petitioner, petitioners, the applicants petitioners want to withdraw the instant interlocutory application as the applicant's petitioner would file appropriate pleadings seeking amendment. Full stop. Yes, Mr. Talukdar, Mr. B.J. Talukdar, learned senior advocate assisted by P.R. Mohanto, Standing Counsel Revenue Department for the OP number 1, opposite party number 1, and Mr. B.J. Talukdar, learned senior advocate assisted by Mr. A. Chetri for the opposite party number 2 and 3. Have no objection to the secret. Post in view of the above submission made by Mr. Sinha and counsel for the applicant's petitioner, the instant interlocutory application stands dismissed as not pressed.
Yes, ma'am. Item 52 the same.
Same. Okay. I had to read. I had to read petition.
Oblige.
Read petition को order pass करो ना भाई.
Oblige.
Please, your lordship.
53.
Lordship. Chief, we filed IA for substitution of the legal heirs of the deceased appellant number 1, lordship. And another application under order 22 rule 9 for setting aside of abatement, lordship.
Abatement, 90 days. No,
How do you buy it? Yes. Which one is to be allowed first? I'm not very conversant with
Substitution,
CPC. Yes, Mr. Talukdar. I'm not conversant with CPC. I CPC do.
Substitution then after abatement, lordship.
Huh? Which one is first?
Substitution.
Order 22.
Yes, lordship. Then abatement.
Why it is abated?
Lordship, 90 days.
90 days.
Already
When he
exhausted.
expired?
26/10/2023 as per
20?
6/10/2023. Next time.
16.
26/10/2023.
Then you have, it has to be accompanied by an application seeking condonation of delay.
Yes. And in IMM,
Madam,
in a petition, there is no
Condonation also.
limitation.
petition. Na tumi substitution na file na koilo. This हो गया then.
At least I am that much convergent. Order, I think. Application in specified cases. Under the Code of Civil Procedure, to have the legal representative of a deceased plaintiff or appellant or of a deceased defendant or respondent made a party. 90 days.
Yes, Lordship.
The date of the plaintiff, appellant, defendant, respondent, as the case may be. Entry 121 under the same code for an order to set aside an abatement. Period is 60 days.
Yes, Lordship.
Otherwise, you have to make an application. When did you file?
I am grateful.
Oh, it is there already. I have not seen. See. Go through it.
Yes, Lordship.
Period of delay has been counted already. I think both requires. Both would require. One is 60 days, the other is 90 days.
90.
Go through the provision.
60 days from the abatement.
You should have provided the assistance instead of on the prayer of MS.
M does not.
M does not consider for a petition. Release the case after review.
Lordship, interim order passed earlier.
How can everything goes?
Can it be after 2 weeks, Lordship? I will not be available for work.
2 weeks. You file appropriate pleading. I think go through entry 121 and 122.
And in fact, petition is not maintainable. In the other side, Lordship, petition is not maintainable. I will maintainability.
That will be different issue.
Different.
54.
May it please, your Lordship?
Yes.
Office note dated, Lordship,
Office.
28/3/2024. Service has been completed in respect of respondent number 6, Lordship. Kindly matter may be fixed for hearing, Lordship.
Hearing, not yet admitted. Heard.
J.
MS.
Ghosh. J. Ghosh.
J. Ghosh, learned counsel for the petitioner. Mr. B. Tolgar, learned senior advocate. Assisted by Mr. H. 3, learned counsel for the respondent number 1, 2, 3, 4, 5. In view of the office note dated. In view of the order dated 28/3/2024 of the Lojima Code, the service of notice upon the respondent number 6 is treated to be complete. First of, as all the respondents or serve the notices, release the case for admission, it's the repetition for admission after that.
Obliged lordship.
Finish out, right?
Item 56.
Also, my lord, step is the matter, my lord. We have taken up the step, my lord.
Steps?
Yes, my lord.
No step. When you will take?
Copy was served on 30th of to the standing council on 30th of last month, and register post was submitted on 3 of this month, my lord. But 3 of this month, my lord.
3 of this month,
my lord. In the
dated 3/5/2024 says no step.
But yes, ma'am. But the receipt was given to them only, ma'am.
What, Mr.
M.A.I. Hussain.
M.A.I. Hussain, learned counsel for the petitioner. Petitioners.
My lord.
Vijay Talukdar. 4-2.
Lordship, I'm appearing on behalf of MD Bora, respondent 1.
MD Bora likho. Mr.
ZH Bora, appearing on
Z,
behalf of
Z.
ZH.
J or Z?
Z for
Z.
Z for zebra.
Z. Zebra. ZH Bora. Learned counsel representing Ms. MD Bora, Standing Counsel, Transport Department for the respondent number 1, 2, and 3. Mr. BJ Talder, Senior Advocate. It's assisted by Mr. Suresh, 8 and 3. Learned counsel for the respondent number 4 to 7. Mr. So-and-so, learned counsel for the petitioners, has submitted that he has taken steps for service of notice upon the respondent number 8 and 9.
All are taken
by taking steps, on 3/5/2024. In view of the above submission made by so-and-so, learned counsel for the petitioner. The office to verify the same and release the case after 4 weeks.
Receipt has been given to them, my lord. Talavana has been given to the morning, my lord.
3/5 you have said.
Yes, I have submitted on 3/5
So
on the evening area, but
it will go again 4 weeks. Same thing. You have not taken steps after 4 weeks.